assignment page by page number 6, till number 19 to 24.
Till number 25. February will have 5. This is an interim order in the lead set.
Moderate still.
Page 7, till number 26. Page 8, till number 34. Page number 9, till number 38 to 40. Question answer. Till number 1.
The petitioner is running in different premises. A committee was formed and the committee issued me a notice and I replied to the notice. I specifically my replies categorically that because of the COVID-19, to maintain social distance, we have taken an adjacent building on rent to maintain social distance in this area. But now what has happened, though this reply is given annexed A, final notice is issued wherein I will take my notes for take a Muravante reservation between continuity. You can take a photo of context to because this was Muravante. See, they are telling because on this side are not causing any interference. It's not money on rentals and all. Still, this is a private person. Syllabus alone. We have taken no objection as per annexure B. The document kindly see annexure B. Certified education report. All the government. And a plan for unexpected. This objections are- Number 4, saying that this is the unauthorized school. That is the threat I have, therefore I am.
What is wrong?
The alternative arrangement is for the reason of COVID.
Because COVID, you cannot violate the rules and regulations.
So I have respected that rule.
You read annexure G, page 29, read the first, second paragraph. This no objection certificate. 29, page 29. So no objection certificate is issued subject to following condition. Read the second one. This no objection. Mail one done. Read the next one.
Yes. On the basis of SLOC, that was application yes or the recognition it has to comply with the
You're running which class? Which standard classes you are running?
I'm running classes from grade nursery till standard.
The same premises.
Same, not in the same premises. This is always an alternative. Few students.
Which class students you are shifted? 8, 9, and 10.
This is very carefully arranged.
So that premises not belongs to you. It's a rented premises. Yes, madam, what is your? You must have given a reply to your letter. Consider that. Oh. No, I understand. Even that also says that read para 9 and para 12 of the very same annexure G. Now, be that as it may, he still has to follow the rules and regulations. Now, maybe he is doing this, he is not shifting or he is not starting. Let it be, madam. Now, the reason he has assigned why, you say yes or no, he will come back. Now, again, if the COVID is increasing, you yourself will stop students. You will issue a notification. No, you're going to give notice. If you are satisfied with that, then you give permission. You have to adapt to new situation. COVID is nobody anticipated COVID. Now we are still not out of COVID. Please understand.
Fellows there for all institutions, all
You have to give it to all if the people are willing to do it. He's doing it.
Come back here, violating. There is a reason why.
These kind of things, you can't go with your typical stereotype government mentality.
There are.
All right, you go before them and find. Now this is a show cause notice given to you. You reply. Try to annexure A. Annexure. Learned counsel for the petitioner. The AGA exception notice for respondents 1 and 2. 1 and 2 only. It is submitted by learned counsel for the petitioner that the petitioner had obtained permission and recognition to run the school. Where is your address? 75/1, is it? Fifth block, 3rd stage, Bangalore. At number 75/1, first C cross, revenue layout, 5th block, 3rd stage, Bangalore. For pre-primary classes. What about higher? Have you stated which paragraph? You show in your petition. So 320. What is this 75? For the higher primary school, you have this 320. Petitioner obtained permission for conducting classes for higher primary school. High school, allowed. Middle school and high school at number 282, 3rd stage, Panchayat, Bengaluru. 282 or 320? Number 282, 320, 3rd stage, Panchayat, Bengaluru. 85, pin code 80. But in view of the present COVID-19 pandemic situation, petitioner temporarily shifted the higher high school students to a temporary accommodation adjacent to this present existing school. I shifted to adjacent, so just shifted to number 282, 3rd stage, Vanashankari, Bangalore 85. 282 to 320 yesterday distance. In view of the petitioner having shifted to the new location without having not sought necessary permission or recognition, annexure notice came to be issued by the respondent. The final notice came to be issued at annexure A. Petitioner has replied to the said final notice at annexure U the respondent shall consider the reply of the petitioner regard to shifting of the premises on temporary basis in view of COVID-19 pandemic, and that he would shift back the students to the original location where permission was granted at number 320, 3rd State Pension, and pass suitable orders. Till then, the petitioners, the respondent shall not precipitate the matter with regard to pursuant to issuance of connection fee. You keep it pending. You go and participate and show your bona fides and seek permission if you want to continue there. What's the difficulty? Now, if you want to continue that and you are paid in lakhs of rupees, seek permission and recognition. They will inspect and grant till next date appear. IA for dispensation allowed for the time being. Counsel for the petitioner to furnish the same 4 weeks. Next. Yes, Mr. Virupaksha.
Previously was not to the past. I said you know that page 98 I said you. Drawing was the recognition granted in favor of the that order was challenged before the song court was
98.
I said you.
Yeah.
This is the order was dated 8/3/2023. Passed by the respondent PDPM was drawing the recognition granted in favor of the petitioner.
Right.
Was on the ground that was the petitioner institution has constructed the building in survey number 128. And there is an additional extent of land which the petitioner has taken on lease. On the ground that the building is not situated in the additional extent. And that the previous extent of land is not converted land on the ground that I have not solved the document to the areas. The order for recognition was withdrawn. Annexure R at base 100 is the order. Thereby, the order withdrawing the recognition was set aside. Page 104. Entire exercise was taken up by the DDPN on the basis of a complaint lodged by a person running the institution within a distance of 200 meters from the state. At 104 para 6. Para 5 narrate. Yes. It is contended by the Learned Council for Petitioner that by obtaining the permission they had reviewed the necessary documents to an extent of 38 kuntas, which is owned by the petitioner trust itself, and another extent of 2 acres 4 kuntas is taken on lease, and the recognition was granted by the respondent authorities to run the school. However, on the basis of the complaint lodged by the person stated above, the recognition of the petitioner's school has been withdrawn, and the same is illegal and contrary to the recognition granted by the authorities. It is further contention that the complainants have no manner of right or interest or local standing to challenge the recognition granted, and the consideration of the material placed by the petitioner before the authorities for grant of permission to others. The ulterior motive of the complaint is lodged, and succumbing to the pressure of the complaint, the state authorities have withdrawn the recognition. Presentation.
He served here. Already he'll give one. Already he'll give one copy. Yes. Further. What has happened now?
So this order para 7 on resolution of annex H and the reply given. It is seen that the petitioner has placed all the materials and documents with regard to owning the land in survey number 128. An additional 2 acres 4 kuntas of land in the opposite survey number. The issuance of annexure L especially appears to be without any authority and without considering the document
Already they are directed to reconsider.
The order was passed on 14th of March. Plus, we obtained the copy on 30th of March. Plus, on without awaiting of the order of resolve report on 20th of March, the connection team. A similar notice was issued by the respondent authorities, making very same allegation. This honorable court had directed me to furnish all the documents. In fact, we had submitted all the documents with regard to owning of extent of land in 2 places. Now, very same allegations got to pay 110.
Who's the complainant?
Complainant is the person who is running another institution. He is connected.
He will be fair, he will be fair, but you have to be fair. It's a government. You give a copies, 230. Give a copy. 230. Can't get succumbed to some complainant. Madam, why you should give him? Why you should give you? Why you should give you copy? Why you should give you copy? No, no, no. You want me to pass an order? You have received copy. Why he should give you copy? It is not shown. It is served here. You, at the instance of government, this rule came to be incorporated for your kind information. You see this. He is not going to serve you copy. You go and find out from your office. It's already given to the AG's office. What is this? You request he will give. You request he will give that. I don't think as per rule you are entitled to. He's already served a copy on the AG's. Why he should give one more copy at his cost? You say you take time. You take time. No problem. But because he has already served, this rule 4 came to be incorporated so that you are given an advance notice by the government gets an advance notice. That is why the High Court has amended, incorporated this. We will not take up any matter once it is not given to you. We understand your situation also. But again, this is a clear case of abuse where some complainant is trying to take it for granted and I think getting influenced, you are getting influenced government by that complainant. Copy kodi on the orge 230. Listed at 230. Take instructions, madam. Not process for the issue notice to respondents. Then the AG is directed to take notice for respondents number 2, 3 and 4. Copy kotigera. The learned Deputy Solicitor General to take notice for respondent number 1. Skill development. Meanwhile, learned counsel to rectify the objections raised by the registry, 2 weeks time granted. Required copy of this certified copy of annexure A. Here, please. Three. Right. What ground? Mostly for what?
Because of these issues, an extra cheap added
Wait, madam, you consider it. But you have said one word, one sentence. You have to let them know how he is going to know. Produce that. Monday. Just because there is a window which is closing, let us see what is the speaking order made by them. If it is in order, then you have to probably print out another alternative. If there is no speaking order, then we'll have to direct them to make some. AGA exception. You are taking notice for 1 to 5? Well, In this fight 2 times. Why you made police station?
Same case, my lords. My lords had made an observation saying that the state remained for 6 months, my lord. The petition number 3230, my lords. It's an annexure, my lord.
Why have you made police station is my question. What for what section?
Yeah, that
So the instant parents not covered. Parents. Parents complete filed. Although they filed an application, now the application attaining the penalty orders to pass. They did actually start this without the affiliation. Now there was an order to penalty which we have complied with by rejecting their and gave instructions.
We are taking notice for all respondents. AG accepts notice for all respondents. Copy served to you. We discussed this matter on 7/18. What is this document now you are furnishing? It is given copies. File it in the registry. Meanwhile, what is the objection raised? Original certified copy and better copy. Keeping open the office objections.
Right?
Office objections are kept open. Huh? What the other? You are able to read Annexure A. Read. Read Annexure A. No, even simple English is not read legible. Hmm? Who appears for the Rajiv Gandhi University? The Rajiv Gandhi, here, Sachin, huh? You take notice? Issue notice, Leonard Council Sri B.S. Sachin, who is in the panel of university, directed to take notice for respondents number 1 and 2. Learned Council for the petitioner to furnish 2 sets of copy of the writ petition to the Learned Council correspondent. Meanwhile, Council to comply with the objections raised by the registry. Relist next week.
Number 6.
What happened to the service of notice through court? Okay. It's an alternative service. I don't understand. It's an alternative service. Along with the court's notice to be issued through RPAD and through court, you are permitted to take out notice through to the council. The main course of service of notice is through RPAD. Please don't. I don't know why you don't understand the order of the court. A week's time granted, take out process, pay the process fee for issuance of notice to respondent. If this is given and if they appear, then that will, or bandidre, it will not be required. Or yaru bandil. Next. ಇದೆಯಾ ಇಂಟರ್ ಮಾಡಲ್ ಇದೆಯಾ ಇದೆಯಾ ಇಂಟರ್ ಮಾಡಲ್ can operating extended till next week.
7.
To which time granted if needful done issue notice to respondent. Same order.
7, sir.
To which time granted to comply.
Employees.
What do you want? To which time? Minute, 1 minute. Those can be many memos made by the council to petition. Said come up last week also, I think. Oh, I saw the same thing by one more case is also there like this. Same order I read, one more. But this is, whether this is coming up for the first time now? Earlier it. This is some objections are still there. Already you rectify the objections, then you can move it. What is objections? This is a review petition. Viewing of what order? What is that order? Measure A. All right, who is the petitioner? Grantee. But you rectify it is for you. You have kept quiet for from 2013. You have not moved your little finger. Not interested. So you're grantee or purchaser? Senate Council for the petitioner seeks time, to which time granted to rectify the objections. They order in matters are the same order.
11. Right.
Who's R2? College. What happened? You have given approval. You have given approval for 5 years course also. What is the difficulty now?
So they are taking the. No one prepared to write the exam.
All right, let him write the exam. So we'll keep the result withheld. Write the exam. That is your risk.
That is my.
Risk. You are ready to take that. Purple. The counsel for the petitioner. So also learned counsel for the respondent number 1 university. The counsel for the petitioner filed a memo. This is not the way to file a memo. Filed a memo along with the approval of admission of candidates. A letter dated 16/3/2023 issued by the respondent number 1 university pertaining to 5 years BBA LLB and 3 years LLB program for the academic year 2022-2023. It is seen in the said letter that the names of the petitioners have been approved by the first respondent university. Approved for admission to the second respondent college. In view of the same, the petitioners who are now in the process of taking up the ensuing examination, having paid the requisite examination fee, required to be issued with the hall ticket and admit card. It is stated that petitioners have already paid the examination fee to the second respondent college, and whether you have received the fee. If they said already, if the said fee is paid to the second respondent college, the respondent number 2 college shall transmit the said amount of fee to the first respondent university on receipt of the said amount of examination fee. First respondent university shall issue the admit card and hall ticket subject to the fulfillment of attendance requirement. When is the exam? Okay. The hall ticket shall be issued 1 week before the commencement of the examination, which is scheduled to commence on 18/4. Well, 1 week 18/4 is shall be issued before 18/4, 1 day prior to 18/4. So you'll have to do it before 17. This, however, the results of the petitioner shall be withheld. The same shall be released and declared only with the leave of the court, this court. To find out whether you have paid the fee, you have to pursue with R2. R2 is not before the court, and R2 has to give it to R1. You have taken hand summons, or you have not taken notice to R2. So meanwhile, counsel for petitioner to do the needful for service of notice to R2. You have to pay PF. Who has signed this application? Who has prepared this application for recalling? Your fault?
Yes, sir.
So hearing for the petitioner. So though they have filed application for recalling, they are not here. This is for the second time. Coming for the first time. Where are the advocate? Who's the advocate?
Okay.
Who's this Sridhar? Who's this advocate Sridhar? Have you seen him? How old is he? Yes, what do you say?
Sister concern would be the bank has filed an FIR, complaint given against the.
So what is the meaning of this?
I guess, 966, sir. Pay is directly responded to the section. Making an application for the well, as per directions, you have paid the amount to the petitioners, the petitioner has paid the amount to the system concern. Even the paid also had it. Second, they complete the inquiry, submit the final report. Third prayer is directly to the.
That's no representation on behalf of. Though this matter came to be dismissed on non-prosecution wide order dated 27th October 2022. The said order of dismissal also stated that there was no representation on behalf of the petitioner. No representation better. On non-taking of steps to respondent number 4. Came to be dismissed for non-taking of steps to respondent number 4. Even today, there is no representative on behalf of petitioner despite an application for recalling having been filed in IA number 3 of 2022. Learned counsel for the respondents are present before the court. Release this matter on Monday, 17th. This Sarvana. Pleading application is to be considered. It's order of stay. What? What is your case? You're a bank. He's a borrower. You're a guarantor. He was passed. It's the first order. What's this? What are you challenging? Number 7. Who are you?
Yeah.
Yes, Mister. What is the? Huh? There's a repetition. You're appearing for the bank. Who's appearing for 213 government? All right. You want to come on record for reading applicant? Yes, please submit the facts. You just submit, let me understand. Where is that agreement? Where is the agreement? Your respondent one, have you filed statement? Where is it? So he's a guarantor. Who's the borrower? Who's the borrower? They have nothing to do with the firm or the company. For the loan. For the loan. How much? You first submit the facts, let me understand. Your case is he's the guarantor, you have paid some amount, the borrower is not before the court. You have not filed any case against the borrower. What happened to that? All right, whether borrower is traced, you are not able to realize the money. The KCET, please. Yes, yes. Yes, you can submit.
Also the guarantor they also under the Supervision Act. Because every however, their contention is one of fraud. That this security interest is created already. Right? But that is a petition.
They have appeared before the DRT.
They have they have now the DRT is not still
Which DRT?
Sorry, This is allegation of fraud. Then these allegations of fraud made in a stand in the street or will constitute. Second is not that they are pursuing parallel remedies. Therefore, by document relation, we are not entitled to proceed under different cities. But this is a big statement. That is the contention. Both contentions are ideal. This is some substitution. Now, we are going to take a look. Not that you apply. Takes in which there is a
So what has happened with the? So nothing has happened in the DRT because there's no sitting. So that is in. That is the benefit. That is the benefit for the petitioner.
Yes, sir. So to say, the way is very. But we are entitled to see that it's securitize the security interest rate market. That is a separate remedy that we are entitled to see. And that is the subject matter of the litigation. Therefore, what is germane for consideration to the lordship is whether we are entitled to see that it's a credit. For these two reasons, one delegation is not. Secondly, we are pursuing parallel remedies. These are the questions. Or use of the line in the application. Say the deed the real owner, where some liquidity is there.
Who has given the gift?
I don't know that that's not the submission was submission.
Belong to?
Thereafter, the register that activity was cancelled. It was executed by 1/9/2000.
Japa had 5 sons. Who are they? Other than these petitioners, Kunjappa had somebody, one more son. The 5 sons. 5 sons are read. Will refine. Then why can't you at least be clear on your facts? There's one lady there, she's also a son. He's also not clear. You are also not clear. Who are you? So you are the grandson. Your son of Mariappa. Kunjappa during his lifetime has given a gift deed to you.
Yes,
Registered.
Yes, sir.
15/9? 15/9/2014. When is this agreement? Prior to that. Prior to that. All right. No. DRT, when did you initiate DRT? OA. Well. So as on 2012, Kunjappa was the owner of the property. So, petitioner salary. Even now, even at that time, 2000. And where is the right he gets? How does he get? How do you get? When your children of Kunjappa, when did you get the right over the property? Basic fundamentals ಗೊತ್ತಿರಬೇಕಲ್ರಿ ನಿಮ್ಗೆ. These are the basics. No, you're set up by him. You're being set up by him. Right? What suit have you? In 2000, much after the proceeding. These are all. Even I was on the other side, sir. These are all things that can happen after the. Sir, please tell when is your family arrangement? All these family arrangements, settlement deed, gift deed will come up immediately after you mortgage the property to the bank.
One suit was family. Second suit, we filed an order to do the by some other property in the co-partner. Family, joint family.
You copy to the council and even to the petitioner. All that you submit, why the interim order should not be extended now? What? Where is that? Where is the finding of the DRT? No, that is your allegation that you have made. You have made an allegation against the bank that there is a fraud. My claim system was a lot. Surfacing your proceedings, you have. Under the Surface Act, there is no appeal. Huh? They filed. I think there is a provision for appeal. Appellate Tribunal Section 18. Section 18 appeal.
17.
And there is an alternative remedy available, go there. Explore. Why this court should interfere in 226? You show there your rights, whatever rights you are now agitating before this court, go take an order from there. Any person, including borrower, aggrieved by any of the measures referred to in subsection, may make an application along with fee to the declaratory tribunal.
Normally, I can, and I'm already into the DRT level.
No, according to you, if DRT is not proceeding in the matter for whatever reasons, you can go before the other forum. Which is the other forum for him?
But he's already gone before the other forum. Person who is trying to have say, but the say is not getting it. Oh, sorry.
Before the whether orders passed, any orders passed?
Why the application will be application? Now, they can do not first. Other matter going on here.
So-
And it's not conditional say.
No. Now the proceedings which he initiated before the declaratory tribunal under section 17 has been disposed of. What is the amount due?
Only one submission of my friend is no, this is that I can go before the act. That's not earlier submission of in that.
Proceeding called. All right. All right. You want this court to consider your application? You want this court to consider your rate? All right, you deposit the amount. I will fix a date, but you deposit.
We follow the matter.
No, you can go on. I'll vacate the stay. I'll vacate the stay. You go on whenever you want. It's up to you. No, please, sir, please deposit. You're a guarantor. You're a guarantor. You are also now trying to say you're the owner of the property. All right, you also deposit. You come voluntarily, right? Who was played fraud? Petitioner. They themselves say they are not borrowers. They are only guarantors.
Oh.
All right, now you are the owner. You know the order is in your benefit. The order is in your benefit. So you also deposit. Both of you deposit. Is this kind of litigation? I don't understand. You come before the court, take a stay without paying a single penny for 8 crore. And you now come up for impleading, saying you're the owner. No, we'll consider all your submissions. Pass on. Both of you together, you pay the amount, or either of you pay the amount. It will be here safely with this court. It will secure interest also for both of you. 230. Come up, what is the amount you're going to pay and when? What bank is this? It's a nationalized bank. Very busy man now. He's more busy than Virat Kohli.
Yeah.
What about Mr. Naik? So all of you together want it after vacation. Government is always ready. Madam Pramodini is ready in all fronts. Girish is also ready. So when you are not ready, he is ready. Any urgency in this? All right. Purple. Learned counsel for the petitioners seek time on the ground of certain inconvenience to the respective senior counsels having been engaged by them. Learned AGA and learned counsel for respondent number 6 university are ready to go on the matter. Acceding acceding to the request of learned counsel for the petitioners. Release this matter immediately after vacation. But 35. Okay, serial number 35 also same one. All pleadings are complete. Well. Permission. Just tell them to type it out. You have taken it 11. Himatra idea. Then you can go sit with the office with Krishna and type it out properly. ನೀವು type ಮಾಡಿ 15. Want to pass over? You want to file objection? What is this matter? This is the 2018 3 years. Say.
Okay, this is pertaining to extension of last date of admission and reduction of percentile. So as per the rule regulations.
They are all aspiring medical students. You have replied and finished your. So you have replied to the arguments. She has replied. Where is the scope for further arguments?
No new document, and the only thing is the counseling process is commenced from February. So there was no time, there was no 30 days time at all. 6/2/2023, the counseling.
Whatever you want to say, you submit, argue it now.
The points I have to,
All right, let him argue, pass over. This cannot go on. Whatever is the outcome of the petitioners, impleading applicants also will have to fall in line in this. Who are you? For the applicants, doctors, same is the state. Whatever happens to them will happen to you, right? What is your stand is different from that of the petitioners. All right, you argue.
This person,
Yes,
Not happy for the response in this.
yes,
My lord, I seek a short accommodation, my lord, because the concerned officer was on leave, my lord. He has reported for duty only this morning, my lord. So I received some instructions this morning, my lord, that we produce all the reports sought by this honorable court, my lord, within 2 days, my lord. That this matter will be issued on Thursday, my lord.
all right. Request of learned counsel for the respondent. Union of India released this matter on 13 is not an education day. 17, 17,
Please, my lord. Please, my lord.
17 Jasti, 18, 18th, 18th.
Please, my lord. 18, please, my lord. Much obliged.
File it and give a copy to the other side, Mr.
Please, my lord. I'll furnish the copy to the other side. Please, my lord.
Give a copy to him, and then
Please.
whatever you want to file, you can file it.
Please.
File it in the filing counter, and also serve it on the council on the next date when he.
And one more thing, the supporting document number 1, I filed in filing. The past which has not been, they are mentioning that. No contact. I filed the file. March. But the past which mentioned maybe not, no contact.
I don't know that you have to go and file it in the proper format, then they will receive it.
I filed properly.
I cannot now keep deciding whether you have filed properly or not. That's for the scrutiny department and the filing section to take it. You file whatever you want to file.
till number 18.
For the respondent, my lords.
Yeah, understood. Who's appearing?
My lords, I'm appearing for the university, my lords.
Ah. Huh? Who has to permit? First. Meeting no arts rate that is reached. He has paid already to 10 lakhs last time. What instructions when you have already received some payment and is willing to pay the balance amount also? What instructions? We can't wait. Will you permit him? When is the, you have finished the course? With whom? Same college. Let him do the internship. The password Madhuri. Password.
Till number 19. Number 19.
No representation on either side. We list after 2 weeks. Hmm? This petition. Come. Two children residing with what's the distance from T Narsipura to Chitradurga? Yes, what is your objection? For what? Okay, I will pass order, then you can verify. To argue the matter, argue the matter. From what instructions? This is a transfer petition. What document you want? You have filed a section 9 petition. He's filed 125 proceeding. He's asking for transfer from T Narsipura to Chitradurga. What you are going to say? Simple thing in transfer is why it cannot be transferred to the place of the residence of the wife. You are participating in 125 proceedings in Chitradurga. It was a Passover day. Passover. Virupaksha, you are ready in this matter. There is the transfer of what matter? Suit filed for what? Filed by you.
I filed was the seeking was the probation was the legal.
Who is the contesting respondent?
Response
Vilwala. Where is R1? Why is bank party?
the party which I have got to transfer there was this suit which is filed by respondent number 1 I'm seeking for transfer from.
What is the suit filed by R1?
He is filed to declare that he is the owner of the procedural property.
Is required. R1 is
In
required.
respect of the very same procedural property, there are two pending. I think what is the number?
Maybe R1 is required to pass orders.
The he is the contesting party.
Or even get him.
Serial number 22.
Naveen. There's no representation. Relist after vacation.
23. Another movie.
Same one. No representation on either side. Relist after vacation.
Go. District.
Especially within the respondent reason before the trial. The trial court may not, NC case has been registered under section 25 of the section 25 of the Hindu Marriage Act. You know, the petitioner is the wife and the respondent is the husband. By the petition under section 25, seeking maintenance of rupees 15,000 per month from the wife.
Who was filed?
The husband has filed.
25.
Under section, petition has been filed under section 25 of the marriage.
What is section 25?
Petitioner has filed, the respondent has.
Oh, you are defending.
No, my lord, I am for the petitioner here. The petition here is a respondent to the trial court.
What is 25?
Yes, the husband he has filed a petition under section 25 seeking maintenance from the wife.
What is section 25? I'm asking you. The section 25 can be filed as a petition by itself.
It has to be filed as an application in the first
No,
place.
I don't know. What do you do marriage act? Now you want transfer of this from,
The trial court, the result for.
have you participated there? Have you filed wakalat in Mysore court? No. So summons Panthan, you're here before this court. Immediately.
This matter came to me through the High Court Legal Services. So the Wakalat has not been filed in the.
So this is the Legal Services Authority. And the other side, notice has to go, is it?
Yet appearing more involvement in this.
Or do you want to counsel for the emergent notice to a respondent? Notice on IG number 1, there shall be stay of all further proceedings in MC number 783 of 2022. Pending on the file of 4th additional municipal family court at Mysore. Till next date of hearing. Have you read section 25? No. Read. How many years you are practicing? 6 months. Now go read section 25.
Heavy.
Patna. Where is that? Patna is where? So you want transfer from Maddur? What's the distance? Well, Bangalore in the 120, then you Maddur in the 120. You have traveled to Mysore from here. But must be 40. Huh? 40 kilometers maximum it must be. 1.5 hours we reached now from Mysore to Bangalore to Mysore. Oh no, you are now asking from Maddur to Patna. Address now pending before Maddur court. It's a distance, madam. The file. Just kilometers. Illegal. Bangalore in ನೋಡಿದ್ದೀರಾ ನೀವು? 120 ಅಂತೀರಲ್ಲ. So you have filed 125. He has filed 13-1. Third learned counsel for the petitioner. Issue notice to the respondent. Learned counsel for the petitioner, along with the regular service of notice, is also permitted to take out notice to the counsel representing the respondent before the senior civil judge at Maddur. Before the court civil judge at Patna. You have filed wakalat there in Maddur court. And also in the before the senior civil judge Maddur. This one I want. That shall be stay of all further proceedings in MC number 77 of 22 on the file of senior civil judge Maddur till next date of hearing. Srikant Patil. Insurance. Claimant's appeal. Yes, madam. Injury case. Does it call for enhancement? Just does it call for enhancement? The enhancement ಮಾಡೋದು ಏನಾರ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಇದೆಯಾ? ಯಾವುದು ಕ್ವಾಂಟಮ್ ಅಲ್ಲ. Whether multiplication or on the disability. Doctor examine ಮಾಡಿದಾರ? ಇಲ್ಲ. There's no representation on behalf of appellant. Relist. Next week. Just inform that Srikant Patil. Nagaraj. Yes, Mr. Nagaraj.
Wife is residing at Mysore along with her parents and a school going child, my lord, is studying at Mysore. My lord, the petition which is filed by the respondent in unable.
What have you filed?
And
What have you filed?
in that we have filed series, my lord, under DBI. Series 547 of 2018, in which the order was passed, my lord, so that shelter is 6 lakhs. He did not pay that. Then again, I reopened the case and FAW has been issued that it's published. Again, second case, my lord, series again filed under 125, series 229. in Mysore, where maintenance has been ordered 6,000. It's almost outstanding is like 10,000. That is also not being paid. And the recovery proceedings has been initiated in Mysore. Is not appearing.
Do you have any objection? No, you have objections. You are argument, madam.
These are all the proceedings pending in Mysore, my lord. And he is employed in ISRO, my lord, drawing handsome salary there. It's 80,000 plus, my lord. His her parent, his father, maybe his carpenter has no regular income at all. And so to attend the proceedings at Karnataka, she has to come all the way from Karnataka. It's around 150 kilometers. And even he has not, despite the order by the court, he has not paid the even maintenance of. He is very arrogant. He says that I'm ready to go to jail also. I don't pay any maintenance.
You must harassment ಮಾಡಿದ್ದೀರಾ ಅವರು.
Harassment ಪ್ರಶ್ನೆ ಇಲ್ಲ.
They need to go to jail.
ಇಲ್ಲ. That is
Already in jail. Huh?
Who the order has not.
ಎಷ್ಟಿದೆ ವಯಸ್ಸು ಎಷ್ಟಿದೆ ಮಗು ವಯಸ್ಸು ಎಷ್ಟಿದೆ 8 ವರ್ಷ ಯಾವಾಗಿಂದ ಸೆಪರೇಟ್ ಆಗಿರೋದು ನೀವು
2017 5/5/2017 ಮಗು ಈಗ 8 ವರ್ಷ she married was right on 5 ವರ್ಷ. And my lord, there is also financial support for her. And all these terms, my lord, I am seeking the transfer of the proceedings.
There is financial support. ಏನು ಇಲ್ಲ. They are not working. Where is the respondent working?
He is working in ISRO. He is a BSc graduate working in ISRO, drawing handsome salary.
ISRO alien scientist.
BSc in some other department, drawing around 80,000.
So, yes. Okay, now I am not deciding your matrimonial proceedings. You are already going for 2 matters.
Question of this division, transfer to maximum. It's a lot of things, but then they have to put
ಇಲ್ಲಿ how well to do ಈ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ಮತ್ತೆ when you are not having anything, you are not given anything, that is why you are behind the bars. You are having your hands, legs and everything fit and fine. No, you are having hands, legs and mental capacities fine, or you are not disabled, mentally you are insane. That you explore in the matrimonial proceedings. I am not dealing that. I will consider hardship only. Not every now and then, you attend when it's required. You attend only when it's required. That is your wife's prerogative to file cases against you.
But they may not even the KNWC is also filed by.
By him.
That is also being dismissed.
Where it was filed in Mysore.
Mysore only.
He was prosecuting it there.
And on merit it has been decided and KNWC case has been.
How long did it go on?
For 1 year my lord.
Purple. That's all. There's no possibility of joining together or amicably settling. Huh?
Efforts are made my lord.
21 years old, your client is. Her client is 31 years. When you don't want to stay with your husband, my
lord, that's why they.
By the husband or the petition is preferred by the wife seeking transfer of matrimonial proceedings in MC number 87 of 2019, initiated by the respondent husband under section 13(1) of the Hindu Marriage Act for divorce to the senior civil judge and JMFC court at Anikal to be tried along with, what is that CMS number?
Lord, 547 by 2018.
$125. Not domestic violence.
That is, yeah, 547.
The BV Act is in the magistrate court, it must be JMFC. 125 is in which court? We tried along with criminal miscellaneous 620 29 by 2020. Again, it's only recovery. The case of petitioner that respondent has initiated a divorce petition under section 13(1) of the 13(1) within bracket 1, so Roman 1A within bracket 1B of Hindu Marriage Act against the petitioner, which is pending adjudication before the senior civil judge at Anikal. Petitioner wife has initiated 2 petitions against the respondent, one under the Protection of Women from Domestic Violence Act in criminal miscellaneous number 547 of 2018. And the other, what is that, 629? 629 of 2020, the section 125 of the CRPC for seeking maintenance for herself and the minor child. These 2 petitions are initiated by the petitioner wife, which are pending adjudication before the courts at Mysore. Stop. The respondent respondent husband has is participating in these two proceedings. You have appeared, Allah Madam, participating in these two proceedings and attending to the court proceedings at Mysore. Full stop. It is also submitted by learned counsel for the petition that the respondent husband had also filed a custody and a guardianship and wards case, which was filed before the court at Mysore, and which came to be dismissed on merits. On merits after contest. And the respondent husband was prosecuting this custody case at Mysore by traveling from Anekal. Learned counsel further contends that petitioner, being a lady without any source of income and no avocation, and despite initiation on the order being passed in the maintenance proceedings for award of maintenance, there is no payment made by the respondent husband. Hence, she has no source of income and no income for her to travel to attend to the matrimonial proceedings at Anekal initiated by the respondent husband. He further contends that she would have to incur costs towards travel, accommodation and food, along with an attendant if she has to travel from Mysore to Anekal, as she is a permanent resident of Mysore and she has no one to stay at Anekal. Whereas on the contrary, the respondent is able, qualified and having source of income, but has deliberately refused to make any payment of maintenance to the petitioner wife and the minor child. Under these circumstances, the petitioner seeks transfer of these proceedings at Anekal to the court, family court at Mysore. Full stop para. Per contra, learned counsel appearing for the respondent, Srimati Sunita H. Singh, vehemently contends that the petitioner is not inclined to stay in the matrimonial house of the respondent husband, and she has deliberately walked out of the matrimonial house without bothering to stay with the respondent husband along with the minor child. Full stop. The respondent is now presently in the judicial custody in view of the proceedings initiated by the petitioner wife, and he has aged parents to support who are dependent on him, and hence he would not be in a position to travel from Anekal to attend to the court proceedings at Mysore. Learned counsel further contends that the petitioner has filed this petition only to harass the respondent, and despite the respondent making efforts to bring back the petitioner to the matrimonial home, she has refused to join him at the matrimonial home at Anekal. Thereby, the fault lies on the petitioner, and it is not due to the fault of the respondent. Full stop para. Learned counsel further contends that lot of hardship and inconvenience should be caused to the respondent husband, leaving his aged parents at Anekal to travel to Mysore to attend to the court proceedings. And she seeks dismissal of this petition. Having heard learned counsel for both parties, the point that requires for consideration before this court, in a petition filed under Section 24 of the Code of Civil Procedure, the main ingredients for consideration would be the inconvenience that would be caused to the petitioner wife and the comparative hardship that would be caused to either of the parties if the matter is transferred from one location to the other. In the present facts and circumstances of the case, admittedly, the Petitioner wife has initiated 2 proceedings which are pending before the court at Mysore, which are being attended to by the respondent husband. And also the respondent himself had filed a custody and guardianship case again for the child at Mysore court, and he himself was prosecuting the case at Mysore by traveling from Anikal, which came to be Anikal, residing at Anikal, Bandu residing at Kannarghetta, Bangalore. Really stop.
Mysore court is intent prosecuting the case.
He himself was, prosecuting the case at Mysore. But the same came to be dismissed on merits. Under the circumstances, when the respondent was traveling and attending to the proceedings at Mysore, it would not lie now in the mouth of the respondent to say that he cannot travel to Mysore to attend to the proceedings, merely because he has aged parents. Of course, it is the duty of the respondent to take care of his parents. So also it is the bounden duty of the respondent to take care of his wife and this minor child. Stop. Admittedly, if the petitioner has to travel from Mysore to Anikal, he would have to spend a substantial amount for a travels, stay and food, which in any case has not been provided by the respondent husband. And there will be comparatively larger hardship that would be caused to the petitioner than to the respondent in traveling from one location to the other. Stop. Under these circumstances, considering the fact that the petitioner would be also more hardship and inconvenience than the respondent, I deem it proper to transfer the matter from the court, from the senior civil judge JMFC court Anikal to the family court at Mysore. Accordingly, I pass the following order. Petition is allowed. The proceedings in MC number 87 of 2019 on the file of senior civil judge JMFC Anikal is transferred to the principal judge family court at Mysore. Yes, ಯಾವ court? Read into 125 ಇರೋದು ಯಾವ court? Third additional family court at Mysore to be tried along with criminal miscellaneous number 629 of 2020. Full stop. It is made clear that the family court at Mysore shall not insist upon the appearance of the respondent on every date of hearing, unless the respondent himself wants to participate. Liberty is given to the respondent to appear whenever it is required during the stage of evidence, conduct the proceedings, court proceedings. Gopalakrishna, appears. The list next week. Released after vacation. Released after vacation. The first working day. What is this, Mr. Girish? Course. Completed the course. Which examination you wanted to appear? Huh? Fourth year. You have appeared in the exam. You have passed. Results are declared. Cleared. You are for the college. What remains now when you have completed the course? That is your prayer. What do you want now? Henry, Mr. Why? You're in B group. It's a B group matter, sir. Not admission matter. This is B group. Copy kottilla nimage. You give a copy, madam. ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು. This repetition is 21. Oh, it's fine, but you have to find out whether she has completed it within the time stipulated. Otherwise, I will dismiss it, but you will not give certificate. That you don't know. You don't know. You have to complete the course in the particular time. If you don't complete by virtue of interim order, then there has to be an order passed, which you have not made any prayer. What is your prayer? Call for records. Permit the petitioner to pay the term fees. That main prayer is already granted in the interim order, Mr. Henry. What, madam? Main prayer is granted in the interim prayer, and now he is saying he is not being served with copy. Your interim prayer is your main prayer. Main prayer exam barek. Interim prayer exam barek. Interim prayer already granted by this court. I think 2 years back. Find out, Mr. Girish. Subject to the outcome ಅಂತ ಹಾಕ್ಬಿಟ್ಟು petition ಅಲ್ಲಿ. Outcome ಇವಾಗ dismiss ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ? What will happen if I dismiss your writ petition? Or if I don't dismiss infructuous and they don't give you the degree certificate because you have not completed within the time stipulated. Learned Counsel Sri. What is your name, madam? Srimati Jyoti is present for the petitioner. Learned Counsel Girish Kumar R for the university seeks time to ascertain and make a submission. Madam, what is your name? Learned Counsel Vidya for R1 and 2 is also present. Release this matter immediately after vacation. Abhishek. Devraj. What is this, Madam Manasi? I've heard this matter. I'll post it after vacation. He's also not here. So representation.
I'm here, my lords. I apologize, my lords. My lords, it can be called after vacation, my lords. There's no such urgency.
Are you here?
I apologize, my lords.
We'll have it after vacation, Mr. Pat.
Please.
Both the learned counsel are present before the court. Madam, you for Devraj. Learned counsel Abhishek Patil. Learned counsel Manasi Kumar for R2. And what is your name? Huh? No, your name. Sai Leela. Sai Leela for R1, R1, R1 are present before the court. When are you getting your name in the wakalat? Are present before the court. Delist this matter immediately after vacation. Jay Kumar, must be OCA. Shiv Kumar CGC. 1 to 4. JEE main counseling. The interim order? Order. The 21. Representation on either side. We list after vacation. Mr. Swami. All of you are ready, madam. State, you have filed your statements. So you don't want to file. You want to file? You have an interim order? It's an institution. The institution, you filed affidavit. No, you filed affidavit. Oh, you were even directed on the last day.
Ask for the judgment. 10% of the seats. They're ready and willing. But my case is entirely different.
That we will come to later on. Primarily now, in view of the directions of this court.
Yes.
Right.
There's one issue. And that is all. The body in fact include orders also the same. They say that if you surrender the seats, you can't do a. This is what they say.
You ought to have surrendered. You have surrendered. No, have you surrendered?
Because there are no study. We will surrender.
What is the order on 1421?
Was in the earlier one.
That is that 6424. 62.
Next year, another the relevant portion is like 30.
Forensics.
Communication is so the government, agree only in violation of admission is not
No, that has been answered by this court. That if they surrender the seat, then it,
even after that continuing with
continuing with. That is what is the affidavit to be filed by you. Where is that order of surrendering in this case? One 421. 11, 22. The order on 18/11/22. Not complied with the direction issued by the court to surrender 39 excess seats admitted in the management quota. Counsel for the petitioner submitted petitioner institution has filed affidavit with regard to surrendering 39 seats in terms of the order passed by this court. And that the petitioner institution will not take any excess admission. When will you file the affidavit, sir? Four. Whose affidavit is this? Society is running the institution. Society is running the institution. No idea. Society is running the institution.
It's a registered.
Correct. The society registration. After that, the institution. Whether you are society or trust. But here it is signed by. No. Society and trust are two different legal entities, sir. SJES School of Nursing will be a separate legal entity apart from the society or the trust. They will be a parent body. Anyway. All right, read para 4. So when are you going to surrender? You have said that you are to surrender, but whether you are directed to surrender. Now, for which year was this?
This has been passed pursuant to the order passed, not a violation.
Your prayer is for protection, certiorari right to request the endorsement of 2021. We are in 2023, so you should have surrendered in 2022. No, that is what you are supposed to say. That is what in my order last time. They submitted by learned counsel appearing for petitioner institution that he would verify and file necessary affidavit. And place before the court whether petitioner institution has surrendered the excess seats as ordered by this court on 1/4/21 in WP number 6243. Learned counsel appearing for petitioner will do the same within a period of 2 weeks from today. So now you find out whether for the previous academic year, whether they have surrendered, even whether this academic year, whether you have surrendered. That is 23. How's one more petition. All right, when that comes, you take notice.
Another petition for the examination.
When that comes, that you see whether if it contradicts, that time you can submit.
What is happening is just before the examination, they will come and get the even serve the copy of it.
Let them kindly give the number of yeah. Maybe because
Say so, no? Very specifically you say which is that. If you are aware, you also see. If that is for different relief, then it will not have. If it's for writing examination, then all right, now you comply with the order passed by me on 441.
For the judgment, which in fact the state government is relying, and the government is relying. Then taking.
Yes.
And required to submit this is only 10% of whatever. Because that deadline has been followed. It's in view of that, not the legislation plan. I think need to surrender this. So 10% I can surrender. And that is
Where is the 10% coming from?
the judgment was.
No, whether you have that, whether do you have the option? No. Whether do you have that option of arguing that aspect now?
In spite of that, I don't have. Stating that. In fact, mentioning the number of seats. The government is followed, I require only to surrender only the 10% of the admission. Needs to be heard in fact.
Right, but first you have to comply with that surrender. So please tell me, where is it saying that 10% you have to surrender? Where?
Non-constitutional Supreme Court order, it is in the
Ridul Dhar's case. You have that? You have that? Where does it say? All right, you first file the affidavit and find out. No, previous. Just this. Previous for the year 2022, whether you have surrendered and what amount of seats you have surrendered, management quota seats. Adane ivaga helak heliradu. That's what I have said in my order dated 1/4/21/23. You say so, sir. Senate Council for the petitioner seeks a week's time to verify and clarify to this court as to the number of seats surrendered by him in the previous academic year in compliance of the order dated 1/4/2021 in petition number 6243 of 2020. We discuss this matter after application.
In 81-82, they have admitted to
Who has to give the permission? But we'll see that. So you verify, check all that. Wait a minute. Yes, which case? Virupakshaya. You got the copy, madam? Ah.
Yes, Alexa, I am looking what of the sound report. At page 100, by setting aside the order dated 8/3/2022, that's why the application granted in the term of institution was withdrawn by the response authority. This one report was this pass an order dated 14th of March 2020, page 100. Directing setting aside the order of the passed by the BDP and further directed the response state to reconsider the documents which are produced with it.
Yes.
This order was obtained by us on 31st of March. Even after passing of this order, Section S at page 107, the private respondent who was the complainant who had in fact appeared before this order report. On 16th, he goes to the media and makes a statement that the recognition is withdrawn by the respondent state. In fact, on 14th of March, the order of the issued order was set aside. That is the news newspaper. He has given a press meet saying that the recognition granted in favor of the Christian institution has been withdrawn. But Chala Adalita Mandali in the Vanchane is to Pramukya Agara. Vanchane he says that the documents are not furnished and false documents are furnished and the recognition is obtained. This he holds a press meet on 16th. In fact, the Learned Council for the complainant, he appeared before this on court on the 14th when the order was passed by this on court. On 16th, when the this on court had set aside the order dated 8/3. Only with an intention to bring a bad name to the institution and to see that the student this is now the academic year is starting. He runs an institution within 200 meters from the within 200 meters distance where the Christian institution is situated. Subsequent to this, on 16th, he
apart from running education institutions, what else is doing?
Because he does this he is
whether he's politically connected.
He is politically, he is also the president of the association of unaided institutions within Assam district.
Why you did not make him a party?
Because in fact, on last occasion, Hardship had observed that he had no locus at Para 6 at page 104.
Right, but you can make him a party that is interfering. I will pass some orders.
I'm only agreed by the action of the respondent state Annexure 109 page 109 Annexure 18. The order of disarmament court is received by us on 31st of March. On 20th of March, the respondent DDP again issues a similar notice. And propose to withdraw the recognition granted in favor of the copies are sent to the complainant also. It is only at the instance of those persons. Last portion of the notice. But they have sent it to the Hardship below the last portion of the notice. And at page 110
last para.
Last para maybe. ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಸರ್ವೆ ನಂಬರ್ ರಲ್ಲಿನ ಜಾಗವು ಇದೇ ಗ್ರಾಮದ ಇನ್ನೊಂದು ಭಾಗದಲ್ಲಿದ್ದು ಅಲ್ಲಿ ಯಾವುದೇ ಶಾಲಾ ಕಟ್ಟಡ ಇರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 128 ರಲ್ಲಿನ ಜಾಗವು ಪರಿವರ್ತನೆಯಾಗದಿದ್ದರೂ ಅಲ್ಲಿ ಶಾಲಾ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಿಸಿ ಸರ್ವೆ ನಂಬರ್ 128 ರಲ್ಲಿನ ಜಾಗವನ್ನೇ ಸರ್ವೆ ನಂಬರ್ ಇಲಾಖೆಗೆ ಸುಳ್ಳು ದಾಖಲಾತಿಗಳನ್ನು ಇಲಾಖೆಯನ್ನು ವಂಚಿಸಿ ಶಾಲಾ ಮಂಜೂರಾತಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದು ಹಾಗೂ ಶಾಲಾ ಮಂಜೂರಾತಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 4 ಮತ್ತು 18 ಅನ್ನು ಉಲ್ಲಂಘಿಸಿರುವುದನ್ನು ದೂರುದಾರರು ನೀಡಿರುವ ದಾಖಲೆಗಳಿಂದ ಮತ್ತು ದಿನಾಂಕ 4/3/2022 ಶಾಲಾ ಸ್ಥಳ ತನಿಖೆಯಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಮಸೂದೆ 1983 ನಿಯಮ 34 ಮತ್ತು 39 ಅನ್ವಯ ನಿಮಗೆ ನೀಡಲಾಗಿದ್ದ ಶಾಲಾ ಮಂಜೂರಾತಿಯನ್ನು ಏಕೆ ಹಿಂಪಡೆಯಬಾರದು ಎಂಬ ಬಗ್ಗೆ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 30 ದಿನದ ಒಳಗೆ.
So you replied?
They have given me 30 days time to reply. They have sought for us reply on the very same allegations were issued. Now they say on the allegation is made that the land Manoj in which the building is constructed, survey number 128, is not a converted land. That is all the allegation Manoj made in the notice. In the third time Manoj, Parivartana Yagadittaru. Manoj, in the entire rules Manoj, there is no prescription Manoj that the land has to be converted. It only says Manoj, the institution should hold 2,000 square meters of land. I am holding Manoj an area measuring about 3,500 square meters of land. And Manoj, I have stated so, and I have also submitted document.
Whether it is coming within the.
Municipal limits. It's coming within municipal limits. My argument Manoj, two documents I have also published Manoj. In the year 2020 Manoj, Annexure L Manoj, page 21. Government Manoj has issued official notification including this page within this city municipal limits. As such Manoj, in view of the judgments of this Honorable Court, in case Manoj, the land comes within the city municipal limits, there is no Manoj requirement of conversion for non-agricultural purpose. That is Manoj, all laid down by the Honorable Court. And I have also sought
In
for
which judgment? In which judgment?
Manoj, sir, I pass on Manoj, there are two judgments of this Honorable Court.
Then yes.
That is not the allegation. First of all, I read the order passed with this honorable court. What is the directions it should be? Consider the we issue proper notice provide hearing for passing the order. The petitioner may furnish any other document required and providing sufficient opportunity to the petitioner. The respondents are at liberty to pass such orders in accordance with the same compliance. Here we issue an only a notice. What is the notice? Not only conversion. They have constructed the building in survey number 128. They have a lease in 128. But while submitting the documents to us, the other survey numbers they had there was a complaint. Because we had to act. Only a notice.
It's okay. Now you have taken the complaint. But it appears now that it is not just a complaint, it is somebody who's trying to act beyond.
Very well, Manoj, this is because they have filed the reply. We have to consider, still they consider 30 days.
You have replied. You have come on the notice itself.
Come on the notice. Because order Manoj,
You have now agreed by this annexure T.
Annexure T Manoj, and also I sought for the second relief Manoj, that there is no requirement Manoj for conversion of land Manoj for non-agricultural purpose.
That's a matter we consider this.
That Manoj,
Right, that you say so and furnish a copy of this judgment to them.
without waiting on 31st of March Manoj, we the order of this one. Without Manoj even producing the order of this one Manoj, on 20th of March Manoj, they issued the notice. At the instance Manoj of those persons Manoj, for politically motivated Manoj and to harass the petitioner. Even in spite of the fact that this one report had set aside the other order Manoj, they go before the media Manoj and
Who is this person who was issued annexure T?
Manoj said the DDPR Manoj, the
Now, if we allow these kind of things, then there is no. No, correct. No, you have followed. You could have also said everything is in order.
It's really not in order. That is the whole issue, Manoj. If there were, it was in order, Manoj, we have passed it. Now we have called for the documents. They had produced the documents for taking the conclusion earlier, different set of surveillance. The cases they have constructed the school on a totally different.
Manoj, my entire case Manoj. That Manoj, the building. Prior to the grant of recognition Manoj, 3-member committee Manoj, on 2 occasions.
Mr. Counsel, whatever you are saying, there may be some truth in what you are saying. How is your writ maintainable for a show cause notice? You are before the court.
No, sir. The only allegation in the notice Manoj is that the land Manoj is not converted.
How that you don't satisfy them by producing this document?
Because the notice only says Manoj in survey number 128 Manoj, on which the building is constructed, this is not a converted land. And the other land Manoj, which is taken on lease, which is a converted land, there is no building.
Now to read the judgment which you are now.
Yes, sir. The second. Manoj, may I read the notice again? They say Manoj, in survey number 128 Manoj, have constructed building. That is Manoj, That was an agricultural land previously. The institution was set up in the year 1960. In the year 2020, the land where the institution is situated, it is coming within, it has come within the city municipal limits. We declared that it is coming. As such, I will contend that there is no requirement for an order of conversion. I have constructed the building in survey number 128. There is a that the land where the building is constructed is not a converted land. And the converted land which is taken on lease, that is an additional extent of land which are taken on lease. Admittedly, I have taken on lease. There is no building. The extent of land where the building is constructed.
Non-agricultural.
It is not converted.
Converted land.
It is also measuring 38 meters.
How do you read the judgment?
The second judgment.
ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸರ್ವೆ ನಂಬರ್ 107, 107, 13, ಜಾಗವು ಇದೇ ಗ್ರಾಮದ ಇನ್ನೊಂದು ಭಾಗದಲ್ಲಿ ಅಲ್ಲಿ ಯಾವುದೇ ಶಾಲಾ ಸರ್ವೆ ನಂಬರ್ ಸರ್ವೆ ನಂಬರ್ 28 ಅಲ್ಲಿನ ಜಾಗವು ಭೂ ಪರಿವರ್ತನೆ ಈ ಶಾಲಾ 28 ಅಲ್ಲಿ ಜಾಗದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 107 by so and so 107 by 30 107 for so ಎಂದು ಇಲಾಖೆಗೆ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿ ಇಲಾಖೆಯನ್ನು ವಂಚಿಸಿ ಶಾಲಾ ಮಂಜೂರಾತಿಯನ್ನು ಪಡೆದುಕೊಂಡು ಹಾಗೂ ಶಾಲಾ ಮಂಜೂರಾತಿಯನ್ನು ಕ್ರಮ ಸಂಖ್ಯೆ 4 ನೀಡಿರುವ ದಾಖಲೆಗಳಿಂದ ಮತ್ತು ದಿನಾಂಕ 4 ಶಾಲಾ ಸ್ಥಳ ತನಿಖೆಯಿಂದ ಕಂಡುಬಂದಿದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಮಸೂದೆ 1983 ನಿಯಮ 34 ಮತ್ತು 30 ಅನ್ವಯಗಳಿಗೆ ನೀಡಲಾಗಿದ್ದು ಶಾಲಾ ಮಂಜೂರಾತಿಯನ್ನು ಏಕೆ ಹಿಂಪಡೆಯಬಾರದು ಎಂಬ ಬಗ್ಗೆ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 30 ದಿನಗಳೊಳಗೆ ಇದರಿಂದ ದಿನಾಂಕದವರೆಗೂ ಯಾವುದೇ ಹೇಳಿಕೆ ಬಾರಬೇಕು.
Two grounds which you have said. One is he has given false document. Second is that 128 survey number is not a converted. So when it is falling within the city municipal limits. But why does the state want him to give a judgment? Are you not aware? You are a big team. You are a state. You are a parents' patry.
They can't be on agricultural land.
No, the question of agricultural land fails into insignificance when it comes within the jurisdiction of the municipal limits. Read that judgment. Read the judgment.
First judgment was page 14 was para 15. It is also not in dispute that the lands in question are the limits of the department. Instead of obtaining permission from the district not arise in your fixing of ordinary from inherent from another, there are three reasons another. Not in dispute that the lands are situated in ward number 9 of the Kulapur town and the property is situated within the town municipal council area. The town municipal council has selected development charges from their rights and granted plan for construction of compound. And in the planning area, if it does not the character of agriculture, the deputy commissioner will not get any right to cancel the Tata on the ground that the opponents are not obtaining an order of conversion. Therefore, we are of the opinion that there is no necessity for governments to obtain conversion from agriculture to non-agriculture. The area comes within the town municipal council. And in the background of town municipal council, collecting the development charges are treated as municipal property.
You pay development charge.
Following this statement, we ask
All right, that is wrong with the division bench.
Also, the division bench judgment for us. A declaration for us in this judgment is ratified for para 5.
Yes.
Also, under the circumstances, are also taken into consideration order of regrant is available at annexure A. I am of the considered view that the improved endorsement is by annexure H. Liable to be quashed. Accordingly, the repetition is allowed. The improved endorsement issued by respondent to quashed. The petitioner is declared to have obtained a deed conversion in respect of the land. Please, survey number And it is right here that the petitioner is not required to pay a separate development order. However, the petitioner is liable to pay the fine amount or the development charges as it is found. Thus, in view of the fact that the land in question was how much in the year 2020 a notification is issued with us.
I'll dispose of this petition.
So,
Your petition will not survive now. With this direction, I will dispose it. They will consider. Yes.
Also, whether it comes. But,
Page.
71 Melody. At page 73, if you watch it, this is the notification dated 31st of December 2020. Annexure at page 71 Melody. At page 73 Melody, the fourth column Melody. Serpade Madalada Gramakana Vivara. Satyamangala, Haradadi, Oonadi is there, Melody, the land is secured.
already, survey number 128 does not.
Sorry, that is the schedule, Melody, the boundaries.
128 does not.
Those are the boundaries within which survey number are.
Petitioner is before this court. Not because I'll have it 2:30, madam. Time is up.
My lord, serial number 35, may I seek short accommodation?
If I adjourn ಆಗಿದೆಯಲ್ಲಮ್ಮ.
Acha, please.
Please. Similar to the other batch of matters alla.
Yes, my lord.
They took time, so this mentioned 35 also similar.
Please.
So beyond vacation.
Much.
Yes, Mr.
Please, 36, my lord.
Serial number 37. Is the state government has to respond to it, because we are seeking a direction by your lordship, sir, to fill up the post of the teaching faculty in a high school and also pre-university belong to the petitioner society. They are doing everything. They say that the government says that there is a dispute over the management. Well, nevertheless, even if there is a dispute over the management, it is always the government which is sitting over the appointment recruitment proceedings. And then students should not suffer at the hands of all these things. Therefore, let the state government respond by Monday or Tuesday, whatever it is. Because next academic year, at least, let these teachers be recruited.
Management, how the state is concerned.
I'm sorry, Milord. It is aided.
All right, granted appointment of teacher. So management has dispute, they will sort it out. You can appoint, and if they don't give, then you can give a fresh posting.
That's correct.
For the petitioner institution. All right, you fine. Request release this matter after vacation. 37.
My lord, 36, my lord.
No, one second.
May lordship's kind permission.
May request a date, my lord, because some urgency is there. At least next
after vacation, I cannot give a date, sir. First week of last week of May.
Please, I'm great. Please.
Yes,
Lord, 36. ಅದು ಇನ್ಫ್ಲುಯೆನ್ಸಸ್ ಆಗಿದೆ, ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ, ಅರ್ಜಾನ್ ಆಗಿದೆಯಾ ಅಥವಾ ಏನಾದ್ರು ಇದೆಯಾ? ನಂಜಾರೆಡ್ಡಿ.
No, whether it is now survive for consideration. Petitioner ilval re, Mr. Ashwatthappa.
Please, my lord. Then it is for the academic year 2021.
Any urgency is not there.
No, I have no urgency, no order, nothing. They have filed and left it.
You also go vacation and come back.
Allah, adu one dispose of them.
Vacation hoಗ್ಬೋದು ಅಂತ.
ಆಯ್ತು, okay, ಪರವಾಗಿಲ್ಲ.
This matter after vacation 36. Yes, sir. ಯಾವ್ದ್ರಲ್ಲಿ? Serial number 12. Case reader name is your case reader. This is that RMVG. Monday, Akim, Monday. You can come on Monday. All others were here, respondents. Right. Monday, Akim. 8. Carry the petition. They are ready. The counsel for the respondent number 1 each time. Or inform ಮಾಡಿದ್ದೀರಾ time and release this matter. Move ಮಾಡಿದಿರಲ್ರಿ. He has moved the matter. Let us see what he says. I will. Petitioner institution. Petitioner sues a trust established during the year 1963 to object to establish educational institutions. Accordingly, it started a school in the name of CKS High School, Bhuvanahali, during the year 1963. Pursuant to obtaining permissions and requisite permissions and recognitions from the authorities, in the land bearing survey number 128 of Bhuvanahali village, Kasaba Hobli, Hassan Taluk. According to the petitioner, there are presently 113 primary school students and 225 high school students studying in the aforesaid school. The institution is primarily established in the land bearing survey number 128. Correct, but correct. Institution is established in survey number 128, staying to an extent of 38 guntas situated at Bhuvanahali village, Hassan Taluk district. It's a case of petitioners that in addition to the aforesaid land, petitioner institution is in possession and enjoyment of land measuring to an extent of 2 acres and 4 guntas in survey number 107/35 and other piece of land situated at Bhuvanahali village, Hassan Taluk district, which is at a distance of less than 1 kilometer from where the school building is situated. Stop. The said land has been acquired through deed of lease dated 6/4/2022 for a period of 30 years. The case of petitioners that they had applied for grant of permission by way of an online application for running primary school as a feeder to the high school, which was being run from the year 1963. Pursuant to such application being made, the fourth respondent authority and the 3-member committee conducted necessary inspection after noticing the petitioner having fulfilled all the requisite criteria, grant of permission, third respondent authority accorded permission in favor of the petitioner for running primary school as feeder to the existing high school in the year 2022-2023. This being the state of affairs, one Sri K.R. Nataraj and one B. Shivarame Gowda and Katihalli is another person. Is it?
They are resident of petition. Nataraj is resident of
ನೀವು ಅದನ್ನ ಸರ್ನೇಮ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರ. Filed a complaint before the third respondent authority against the petitioner institution for having concealed certain relevant and necessary material facts and having obtained fraudulently the permission from the respondent authorities. So based on which the third respondent authority issued a show cause notice on 3rd March 23, calling upon the petitioner to furnish a reply within a period of 3 days. To which the petitioner replied on 6th March, clearly stating petitioner institution has not concealed any material facts and that he has made the application via online for grant of permission. Pursuant to the communications made by the petitioner with the third respondent, and on consideration of all the materials placed by the petitioner, the third respondent authority proceeded to pass an order on 8th March 2023, withdrawing the recognition with immediate effect. Stop being agreed by the order dated 8/3/2023. Passed by the third respondent, petitioner preferred a writ petition in WP number 5839 of 2023. After hearing the parties in the said writ petition, this court passed an order dated 14th March 2023. Quashing the order dated 8th March 2023, passed by the third respondent authority, and issued certain directions to the respondent state to reconsider the documents which are produced by the petitioner, along with annexure H therein, and issue proper notice to the petitioner, and also provide hearing before passing any order. The petitioner was also permitted to furnish further documents required, and on providing sufficient opportunity to the petitioner, the respondents were at liberty to pass fresh orders in accordance with law. Pursuant to the order passed by this court in the aforesaid writ petition dated 15th March 2023, the said complainant mentioned earlier, namely Sri B. Sivaramegowda and Sri K.R. Natraj, held a press meet at Hassan on 16th March 2023 and circulated false news that the recognition granted in favor of petitioner has been withdrawn, which was got published in all the electronic and print media to the effect that the recognition granted in favor of petitioner has been withdrawn on the ground of furnishing false information to the respondent authorities. It is further contended by learned counsel that the said persons in fact were fully aware of the order dated 14th March passed by this court, wherein this court quashed the order dated 8th March 2023 issued by third respondent, but has mischievously held a press meet on 16th March only with an intention to defame the petitioner, to see that the institution is de-recognized and public, and to create a bad image in the public at large. The third respondent authority, without even awaiting the orders of this code dated 14th March in WP 5839, proceeded to issue a show cause notice on 20th March 2020, leveling allegations against the petitioner. Similar to the allegations leveled earlier in the show cause notice dated 3rd March 2020. It is further contended by learned counsel that the respondent number 3 in total violation of the order passed by this court has issued the present show cause notice dated 20th March 2023 without application of mind, and hence is perforced to approach this court for necessary reliefs as sought for in this petition. Per contra, learned digital government advocate representing the respondents vehemently contends that this petition itself is not maintainable for the simple reason that the prayer sought in the petition is against the issuance of a show cause notice dated 20th March. And on perusal of the sum and substance of the show cause notice at annexure T, which is questioned before this court, the third respondent authority has given a show cause notice stating that the petitioner has not complied with the relevant rules and regulations, and that it is mentioned that there is no building in the land bearing survey number 107/12, 107/13, 107/35, 107/18, 108/44, which application and which survey number was filed at the time of securing the recognition and permission. But whereas the school building has been put up in survey number 128, which is a land not converted for non-agricultural purposes, and therefore sought for reply from the petitioners to be given within 30 days from the date of issuance of the said notice, which is dated 20th March 2020. Your reply to this? Admittedly, petitioner has not replied to this show cause notice issued by third respondent. And the period of 30 days is also not expired. Therefore, petitioner is at liberty to reply to the said show cause notice issued by the third respondent, void annexure T, and put forth his case with regard to all the contentions that he has urged in this. The primary contention of the learned counsel for the petitioner is that the impugned order at annexure T is similar to the earlier order passed on 3rd March 2020. 3rd March, Allah? On 3rd March 2023. Therefore, there is nothing new that has been stated or pinpointed by respondent number 3 in the present impugned show cause notice dated 20th March void annexure T. Learned counsel for the petitioner also brings to the notice of this court the reason for issuance of show cause notice and for withdrawal of recognition by the said show cause notice is also on the ground that the survey number 128 Kata number 538, measuring to an extent of 38 guntas, is not converted, is not a converted land, is not converted to non-agricultural purposes for the purpose of utilizing this land for the educational institution. He relies on 2 judgments of this court in the case of Hubli Dharwad Urban Development Authority in Navnagar and State of Karnataka and another by the division bench of this court, which is followed by the learned single judge of this court in WP 102638 of 2021 in the case of Samir Siddiqui versus State of Karnataka and others. Page 81.
The previous
Also another judgment in ILR 2012 KAR 3428. It is the contention of learned counsel for the petitioner that the division bench of this court and the court, the single judge of this court have held relying upon the judgment in the case of Muni Narayana Swami and another, when the property situated is within the town municipal council area, and when the town municipal council has collected the development charges from the appellants, the granted plan for construction and granted plan for construction of compound and in the planning area, if it has lost the character of agriculture, the deputy commissioner will not get any right to cancel the khata on the ground that the appellants have not obtained an order of conversion. Therefore, we are of the opinion that there is no necessity for the appellants to obtain conversion from agriculture to non-agriculture. If there are the land, if they are comes within the town municipal council limits, and in the background of town municipal council collecting the development charges, treated as municipal property. It is the contention of learned counsel for the petitioner that the present case is similar to the one which is referred to stated supra, that the present property, this survey number 128, comes within the town municipal council of Bhuvanahali, Hassan district limits, Hassan city municipal limits, and therefore it would no longer be within the limit within the agricultural status as it has come within the municipal council limits. Hence, the question of taking or obtaining any permission for conversion as non-agricultural property would not arise. And more so, the petitioner has paid the development charges and khata. What charges is that? Betterment charges to the municipal corporation.
So connection B becomes is the document.
That you say so. That's why I have said that the property which application is filed for 107 and others.
It is also filed for 128 minutes. Except B is the document.
I'm not holding anything. I'm just directing them to consider. However, all these facts would have to be considered by the respondent's state in the reply that would be given by the petitioner to the show cause notice issued on 20th March 2023. The present writ petition would be premature in nature as the respondents have only issued a show cause notice asking as to why the petitioner institution should not be derecognized or not complying with the necessary requirements under the Karnataka Education Act. Therefore, liberty is always available with the petitioner. Produce all the documents, including the judgments relied by the learned counsel, which is stated supra, to impress upon the respondent state that he has complied with the necessary requirements and that the property in question, if it is the property which has been given for grant of permission, then the respondent state to consider the same in accordance with law and pass suitable orders. Under the facts and circumstances of the case, the present petition requires no further orders. It is disposed of with following directions to the respondent. The respondents are directed to consider the reply, if any, given by the petitioner to the show cause notice issued by them dated 20th March 2020. All other documents, if any, submitted by the petitioner, and consider the same in accordance with law strictly. While considering the said reply for grant of permission and recognition, the respondent state shall keep in mind with regard to the law of the land, with regard to conversion of the property and the judgments passed by this court. Just add one more para about the final. The respondent state, being a parent's patria, cannot act like a private citizen showing ignorance of law. The respondent, it's a huge organization by itself, an agency as a state, with qualified legal experts assisting the state, with a law officer in the to guide the state, should be aware of the law, the land, and the latest law with regard to conversion of land and the judgments passed by this court. However, the respondents shall consider these judgments if they are not aware of the same and pass suitable orders. Operative portion only. The respondents operative portion. The respondent shall consider and pass suitable orders pursuant to the reply furnished, if any, furnished by the petitioner along with documents within a period of 4 weeks. 4 weeks after he gives reply. 4 weeks pursuant to the reply, if any, furnished by the petitioner. Oh, that's okay. Learned order sheet only. Third learned counsel for petitioner. IA1 for dispensation is allowed for the time being. Production of so-and-so is dispensed. Learned AGA accepts notice correspondence 1 to 4.
Number 14.
0. 3.
Not that our time they're not able to implement what are the amount that they are paid. They have to know. What are the amount they are paid?
Have they paid any amount? One minute. How much you have tendered? How much? How much? ಯಾವ ವರ್ಷದಲ್ಲಿ which year? 2011, 3 crores. Yes, what do you say? How much amount you have deposited? No, you may not have instructions, now you pay. So outright, I am going to reject your petition with cost. Mr. Sarvana, you also, you are not merely going to take instructions, you have to take instructions as to how much money you are going to deposit after 2 days. Only then the time is going to be granted to you. Otherwise, I will pass an order asking you to deposit. They may come with clear. Even if they come with clear clarifications, you have to come out, what is the amount you are going to deposit before this court? No instructions, you have to come with a DD. Yes, deposit before this court, you also. You are from Bangalore? You can come through VC. Unless you want to travel to see the beautiful city Bangalore, you can come. Huh? We are Karnataka, sir. We are far ahead. But we'll have it on Monday. All Tuesday. At request of learned counsel for the petitioner and the impleading applicant. We list this matter on Monday, 17th April. Sorry, 18th April. Both the learned counsel for the petitioner as well as the impleading applicant to mention after consulting their clients as to what is the amount they are going to deposit and to show their bona fides by depositing certain amount for this court. Interim order is extended till next April. 14 crores. So now it's 115 crores. We had one client earlier in one case. He is now in JC. So even if he raises his hands and says, now you can send me, you will have to pay bata charges for him to be. So you can think about it. We will let them come with some proposals. Now you have come and hit your own foot, so please don't go. You're here. I'm not going to let you go. So you have one more partner now, either to go to JC or to pay the amount. Correct. Now I don't know whether you set him up, but he has now got caught in the web. So welcome to the party. Serial number? 15. What happened? What's the deal? This entire matter has been heard, madam.
Pertaining to the IA 1 of 23, we have challenged the regulation of the NCIS, National Commission of Indian System of Medicine.
Sir, IA for direction.
IA is to reduce the reduction of percentile in respect of need and extension of last date of admission. Main praise, we have, but the regulation, we have challenged the regulation as unconstitutional.
Main prayer will still sustain. Right. So only thing that can be disposed of is the application for direction.
Basic money.
You should charge.
Because that will cover our office expense at least, no?
Yeah.
Yours or his? So you have also given your synopsis also.
I made my submission. Details have been as only thing is two documents which have to put forth into the submission.
So filing it now. Give a copy to the other side.
Document dated 33/2022.
Yes.
33. This is pertaining to the academic year 21-22. Wherein you will not see there are two the table wherein on the left hand side qualifying percentage and marks range of NEET QG 2021 for admission with respect of ASU right side revised qualifying criteria and marks range. So we will not see 58% is reduced down. So we are not seeking in my IA, we are not seeking that is not done here. And moreover, the extension of time, matter issue pertaining to extension of time, last academic year it has been extended till 10th of May. And this year, Lord, if we not see page number 3, Milord, page number 3. That is the first round revised the schedule for allotment of seats to Ayurveda Unani University. This is the counseling, commencement date of counseling. It is only commenced on 6/2/2023. 6/2/2023. So not even the last date for close of admission is 4/3. Your answer is 4/3, the last date. The next document, page number 4. Your answer is the last date for reporting. That is the 4/3 is the last date for admission. That date we are seeking under my IA. We are seeking extension of admission, last date of admission, extension of time, and the reduction of percentage.
Time is anyway over now. Time is anyway over.
The application was filed earlier itself, prior to the last date itself. Now there is still possibility because the seats have not been filled up. The only thing is, Lord, permit me to present the RTI in respect of admission. Here, Milord sees page number 6, Milord. I will just demonstrate. One RTI document.
Madam, I'm not remembering the facts and what you have argued. So I think both of you, anyway, now you have given this, your statement of objections is as good as a synopsis for IA on one only for direction. So you also furnish that some synopsis what you are relying on. Because I don't find my notes whether it's not available. So you can argue on Monday or something. Tuesday. All right, Tuesday. Tomorrow. All right, you can take a chance on 13. So meanwhile, you can give a brief synopsis what you are only on IA1 for direction. Because I don't remember the facts. Release this matter on 13. Both matters?
Both matters.
15 and 16. Similar, is it? 15 moderate of 13. If any operating is extended to next week.
For 80.
Para Fatima.
Sorry, my lords, for the university, my lords. My lord, this matter is pertaining to the student who is doing MBBS, my lord, but has not paid the complete fee. And she has
Correct. Oh, this is the
This is
case in
between
where
the college and the student, my lord.
that person.
Mr. Dilli Rajan appears on behalf of Mr. Subba Reddy, my lords. He's in the
No,
morning.
he's here. Madam, just see our.
Mr. Nishant. An identical matter, my lords. Last week, my lordship had directed the university to announce the results. Because anyways, with respect to.
So in this case, they have filed an affidavit.
Please.
Of payment. Yes, what do you say, Mr. Counsel?
They are also informed on the same day. Check.
All right, till then you let them, you permit them for internship. They also say they are willing to pay. They are not saying that they are not going to pay. Collective. You are not going to give him the certificate. No, there is no need of a sir. Simple thing. Unless he pays, you are not going to give him the certificate. You will have to approach this court, and this court will have to pass an order for you to release his degree certificate. So now that he is already filed an affidavit with the tabular column of how he is going to make the fee, you accept whether you are agreeable to it or not, and whether you want it to be reduced into 2 installments. Let him say whether he can do it. In the meanwhile, let him continue with the internship course. You can instruct. You want an order? No, I will pass an order. You have made any IE or you have not made? Is that?
Yeah.
27-3. Not 20. Don't start there. Whether there was any order that they will not pass declare the results.
2nd February, my lords.
Results of the petition shall be kept in abeyance.
Yes.
Now you will declare the results, Mr.
My lords, it's the university to declare, my lords.
You will declare, madam. Any difficulty?
No, my lords, if there's an order, we'll do it.
Wonderful. Heard the learned counsel for petitioner and the learned counsel for respondents on the application. A number 1 of 2023, which is filed under section 151 of the Code of Civil Procedure. Wherein it is prayed to direct the respondents to announce and declare the results of the final year MBBS course of the petitioner. Sabrina.
Yes, my lord.
Conduct. Petitioner conducted in the month of February, and also to permit the petitioner to participate in the internship program commencing from 3rd week of March 2023. Stop. You're fine? Learned counsel for the respondent number 2 filed objections to the said application. What is your main contention? That they have not paid the fee. It is the contention of learned counsel for the petitioner that the petitioner, having completed the final year MBBS course, is now deprived of the taking up the internship program because of non-declaration of the result of the final year MBBS course. It is further grievance that by virtue of an interim order, he was permitted to write the examination. By virtue of interim order, you wrote the exam. By virtue of the order of this court dated 2nd February 2023, petitioner was permitted to write the final year MBBS examination, but the results were directed to be kept in abeyance and was not permitted to be declared without leave of the court. It is the grievance of the petitioner that if the petitioner is not permitted to prosecute his internship program, which is commencing from the 3rd week of March 2023, he would eventually lose 1 year, thereby he will be deprived of pursuing his further career and lose 1 year, which will be detrimental to his future career. Therefore, he has filed the present application for the relief stated in the said application. Admittedly, petitioner was permitted to take up the examination by virtue of interim order dated 2nd February 2023. This court restrained the university from declaring the results, and the writing of the examination by the petitioner was also subject to the result of the petition. Main contention of learned counsel for the respondent number 1. Number 2, college is that the petitioner has not paid the fee which he was supposed to pay, and by pursuant to the filing of this writ petition, petitioner has filed an affidavit with the tabular 28 March 2023, an affidavit by the tabular column that he would pay the tuition. So annual fee or tuition fee? Annual fee. Pending fee for 1.5 years in a tabular column stated in para number 7 of the affidavit dated 28/3/2023. Pursuant to that, the petitioner has also paid a sum of rupees 10 lakhs on 30th March 2023, which has been accepted by the respondent number 2 college. Petitioner has also made a categorical statement that he would pay the balance amount within a reasonable time, and he has placed the same to the respondent number 2 college, which is yet to consider the same and accept the same with regard to payment of fee in installments. This court is showing indulgence to the petitioner only on the sole ground of the COVID-19 pandemic having affected the petitioner and his parents for the inability to pay the fee. But however, the petitioner has stated on oath that he would make the full payment of fee to the respondent number 2 college on acceptance of the tabular form furnished by the petitioner. Learned counsel for the respondent number 2 subjects that the college syndicate is scheduled to sit for a meeting to discuss the acceptance or otherwise of the affidavit filed by the petitioner on 15th. Hence, release this matter on 17th. In the meanwhile, petitioner shall be permitted to the respondent university, respondent number 1 university shall declare the results of the final year MBBS course of petitioner. And the respondent number 2 shall permit the petitioner to participate in the internship program commencing from the 3rd week of March 2023, allowing the petitioner to attend the classes. Subject
only minutes if he's successful in the examination, in the results.
Provided the petitioner is successful in the examination, and respondent number 2 shall allow the petitioner to attend the classes if he is otherwise eligible and successful. This order is again subject to the petitioner agreeing to pay the entire fee to the respondent number 2 college. Even otherwise, I will sign before I leave. I am going to sign the order.
I'll inform them. I will inform the others.
Please inform.
We'll do it.
Jagan Mohan. You took time. For what? Your senior is not required for these kind of cases. Yavaginda ನೀವು practice ಮಾಡ್ತಾ ಇರೋದು? 3 months. You're practicing from 3 months. Where? In the High Court or all the courts? Released next week. That's 18th. Entry model extended. Siddhappa, you are from which court to which court? OS number 113 is pending in which court? Chitradurga. 113 is in Chitradurga. P&SC and OS 96 in Chikmagalur. Parties are the same.
Respondent number 1 of the side super declaration was subject matter was this section for us. After going to the
70. ನಿಮಗೆ ಬೆನಿಫಿಟ್ ಆಗಲ್ವೇನ್ರಿ ಒಂದೇ ಕೋರ್ಟಲ್ ಮಾಡಿದ್ರೆ ಫಾರ್ ವಾಟ್ all right, you take instruction, but it will be better for both of you to go before one court, either in Chitradurga or in Chikmagalur, because otherwise you will have divergent conflicting decisions. It will help you also for evidence. Learned counsel for the petitioner is present. Counsel for R1 seeks time. Release next week. 19. Mr. Ajay Kumar Patil, you are waiting for which matter? Idea. Chain matter though. Because one of your matter was urgent because you were not here. No, that's okay. I thought you were waiting for OCA. On the list model. Dispense production of connection A to H and J to M. Yes, what is this, Mr. Huh? Into OCA student. Standard. Parent, they are US, which country citizens? So you have studied from 1 to 10 to 12 in Bangalore, Delhi, Karnataka. Order आगे दिया होगा. अब pass the order इधर. बढ़िया.
There is some speculation.
Anidhar. The file that produced it?
It's a general. Page 41 and 42.
Who was issued KEA?
They say that's only Indian citizens are allowed to register online application. Spite of the order of the embassy. After committing no other mistake, they have issued connection help.
on 23/2023. And there also they said that they are not very clear. They are going to.
Even ಹೇಳಿದ್ದಾರೆ.
As per the order of Report of India, OCI candidates will be allowed to apply online for UGCET 2023 after necessary modification incorporated to the software and the information in this the KEA website. OCI or KO students are hereby empowered to keep visiting the KEA website. They said they are going to do it. After passing of the last order, next document, then they said it is open for the petitions.
No, read that as per interim order.
As per the interim order of the Honorable and subject to the further orders or notification of the state government, orders of the Honorable Supreme Court and provisions have been made for candidates the KEA portal to register and apply for online 7 a.m. on 33/2023, 5/4/2020. Therefore, on the basis of this, we have registered it. But still, there is some situation. Therefore, unnecessary demolish.
4 ಅಂತ ಇದೆಯಲ್ರಿ.
But the end of the was started. So, take care of that is open for 10 to 13.
10 to 13th.
Yes, the last part.
ನಾಳಿದ್ದು.
Indian citizens last day. So, spend on 5.
Phase 11. So ಇವಾಗ for OC.
Abundant caution we have covered. I have read submission. There also Mr. Enkerman said, submitted before this point that from it will be open for particularly OCA student from 10 to 30.
Yeah, order ಅಲ್ಲಿ. ಇದರಲ್ಲಿ 10/4 to 13/4 specifically for OCA students.
For one night.
Same order you will also be entitled to.
Or
Registered. ಯಾವಾಗ ಹೇಳಿದ್ದೀರಾ ಇಲ್ಲಿ? Which para? What is this? Why can't they allow for others? Shukumar, you are appearing Allah for union. So you will take notice in this case also. Mr. Ajay Kumar, why can't the government and KEA allow it for everyone? Why should the public and the students have to come and talk? Why they should come? They are welcome to come if they are filling the pockets of Vijay Kumar Patil and Vijay Kumar. But when such orders are passed, it should be made for the welfare of the entire student fraternity, so that each one is not made to knock at the doors of the court, because they are benefited at large. Because if one OCI candidate is approached and the law is laid down, it is applicable to all the OCI candidates. Third Learned Counsel Sri Vijay Kumar on behalf of petitioners issue emergent notice to the respondents, Learned Counsels, Learned Sri Shiv Kumar, initially there. That's all. Shiv Kumar, who is in the panel of Union of India, is directed to take notice for respondent number 1. Learned Counsel Sri N.K. Ramesh. So the panel of KEA, respondent number 2, is directed to accept notice on behalf of R2. Learned AGA directed to accept notice for R3. Learned counsel for the petitioner furnish one set of copies of the writ petition to the respective counsels appearing for the respondents. Registry to show the name of the respective counsels in the cost list. Stop. IA1 of 2023 is allowed. The production of original of certified copy of annexure A to F and J to M is for the time being dispensed. 4 weeks time is granted to the petitioner to file the certified copy of the said annexures. What are those?
Except for example, other documents are all the supporting documents.
All right, we allowed better. We'll just keep it open. IA number 1 is kept open for education at later point of time. Pending. Pending disposal of this writ petition. Respondents number 2 and 3, na? KE and state shall permit the petitioner to. No. Permit them to participate. Permit the petitioners herein to participate in the online counseling of the KCET 2023. Huh? No, now you have to appear for counseling first. First, CET examination. Oh, sorry. Permit the petitioner to appear for KCET examination. KCET examination as per the notification issued dated 1/3/2023, and thereafter permit the petitioner to participate in the counseling of the KCET 2023 on the petitioners being successful. On the being successful. ನೀವು ಎಲ್ಲ ಇದರಲ್ಲೇ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಸೆಲೆಕ್ಟ್ ಇಂಜಿನಿಯರಿಂಗ್ ಸೀಟು ಮೆಡಿಕಲ್ ಅನ್ಎಡೆಡ್ ಅದು ನೀವಲ್ಲಿ ಮಾಡ್ಕೋಬೇಕಲ್ಲ. How can this court pass an order that what you have to select? It is also stated, but it is also stated by the petitioners, they have already filed their application to online on 1/4/2023. On 1/4/2023. If the same is in order, the same shall be taken up for consideration. And accordingly, the respondent number 2 and 3 shall permit petitioner to take up the KCET examination. In all further proceeding. Correct, but once you take up the examination, that is online counseling only. Once you take up the exam, if you are successful, you will participate in the online. Huh? Sorry, I didn't get you. Sorry.
Then we have to again rush to the court and
take up the online examination. Permit them to take the examination and declare the results the same, and on the petitioners being successful shall permit them to participate in the online counseling of KCET 2020. And the petitioners would be at liberty to choose their respective seats under the government quota or the private unaided and aided colleges as per their choice. Based on their rankings in the said KCET examination. ಇಷ್ಟು ಡೀಟೇಲ್ ಆಗಿ ಬರಿಬೇಕನ್ನ ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗ್ಬೇಕಾದ್ರೆ
ಈಗ ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅನಾಲಿಸಿಸ್ ಸೆಲೆಕ್ಷನ್
they have added one more. They said only for those who have approached the court. This order is passed as similar order is passed in WP number 5656 of 2023, which is relied by the Learned Counsel for petitioner. You serve a copy to Mr. N.K. Ramesh, the state, and so you want me to just on 13th, Allah? Huh? Correct, but whether you want this matter to be posted on 13th for Mr. Ramesh to again do anything? We list it on 17th. No further apprehension. Relist this matter also along on 17th April along with WP 5656 of 2020. This will be sent and uploaded, so you can take it there online. Yes. Yes, sir. So this is also similar, or this is?
last year. And this is the order. If we want to be given to the export,
Yes. Ah.
Yeah, the first release method is very key on select. The challenge is the notification, which has already been applied by the FX.
4th March 21.
4th March 21 notification has been valid, but that was also planned. That notification has been held in the first grade. As far as the first grade is concerned, my lord, it cannot supply. The second one, my lord, re-entry also. Both to participate in the online course. By virtue of the degree model pass based on food as well as the effects. All these OCA students are participating in the
So
online.
here also OCA students. So only thing is here they are for IITs and NIT. So instead of KCET, it is only NIIT and IIT.
NIT and IIT. The examination also is JEE. The names are JEE advanced. Here we have participated in the examination. Results have been declared. We have participated.
So you have submitted online.
Online, and we have what we put in the study. All of us have been submitted in the study. Now, with the pendency of this, the judgment has been called for the FX court.
What is your now prayer?
Now, nothing, my lord, as far as this is concerned, as far as what we have been covered, we have to dispose of it. Subject to what the learned counsel gets covered.
No, now here you are not seeking for any admission.
No.
You have completed the course,
No, not yet. I am still in the third semester.
third semester. So what is your
So
prayer?
the fourth semester I have completed.
No, what is your prayer here?
Now nothing further may survive except dispose of the institution.
Yeah, no, what is your prayer to dispose what?
In terms of the order passed with the ethics code.
That your validity of OCA.
No, not as a validity of OCA, saying that my admission already, paragraph 58 may
We'll come to the judgment. What is your prayer here?
Here, my lord, they are not permitting us to participate in the notification.
Then by interim order, you would participate. You got selected.
Also, we have been admitted for the council. We have pursued those ready to have completed. So the academic year, 21, 22.
So in 884, which NIT or IIT has joined?
Now, my lord, they have got one of them has got the seat in IIT Kharagpur.
Kharagpur.
Yes.
All right.
In some different institutions. One has got in IIT Bombay, one has did not get in IIT, she has got in NIT.
So what has to be done in this time? 58.
Now, statement, paragraph 58, that's all I have.
Read it.
In Burger Gold, my lord, basic, my lord.
Yes, sir.
In Burger Gold, all of the similarly is the card. Entitled to the rights and control on them, appear to the notification. To be availed by them, notwithstanding the participation of the city. In this selection, and subsequent action based on the entry model passed shall stand regularized.
So the interim order stands regular.
Regular. Oh. The admission which we have obtained pursuant to the entry model passed here, my lord.
They have to be regularized. In view of this judgment.
As if they are Indians.
As if you are Indian, Salah. You are not Indian.
But
you are as you are a foreign. You have voluntarily not opted to become Indian citizen. You still remain a foreign citizen of some country.
Yes.
But you want the benefit of OCA.
But we should be permitted to be, or we should be allowed to be treated as Indians. As per the ethics code.
Anushka, please. Anushka. Anushka Rengantuar.
And serial number 32, my lord, which has been rejected. That is also identity. So it is put on. Only in one restriction, 1886 my lord. I need to get some instructions, my lord. It's identical. But the thing is, she has been admitted to IIT Mumbai.
So these two petitions, they just 1, 2, 3, 4, Allah? 34.1, 2 and 3 yes. And 34. 32 is urgent.
But already that.
No, once I have already adjourned.
We called on Monday,
madam. After vacation. Anyway, you will benefit this order.
Only 1886, my lord. Can be called on Monday. Because then she has secured a seat in IIT. But the IIT is charging them her. Charging them for NRS. Thereafter, my lord, I asked her to submit a presentation. And I said, either we will have to file an application in IIT here for a direction that she should be charged on par with this. Or she may have to file a separate application. Bombay.
IIT Bombay, she is taken admission.
Yes.
She has to go file it there.
Yes, filed it there or
so how did you file it? How did you file it here?
No, here it was before the council. Before the council.
So she's from Karnataka.
She's from Karnataka and here for the examination.
So we'll dealing.
One maybe called only on Monday. Dealing present and called on Monday. I'll get this. 1886.
Learned counsel for the petitioner, Shri Ajay Kumar Patil, submits that WP number 18886 of 2021 requires to be delinked from these batch of cases as the petitioner therein has secured admission to IIT Bombay. He requires a few instructions from the client to proceed further in the matter. Hence, release this matter on 18th. All other matters.
All other matters disposed of. Just observing that they should be treated as Indian citizens.
I have already.
I
have already passed order in one of your case.
No.
Not yet. It was reserved or what?
No, that is the TASAs. That is for the last weekend. Where my lords have directed that they should be.
No, that is only an interim order. So this will have to be disposed of on more. So you are not pressing prayer number A, B,
and C.
But you have not stated in each of these petitions to which IIT they have joined. Now we have to say at least.
Now then all this is report on Monday. I'll get the instructions which IIT there.
So what you have to do, just file a memo so that I can say in the order. Otherwise, again, it may create further problems for the students. So that it will come to know that they have been already admitted to such a course. So you can rely on this judgment by presenting this whichever court.
I will find the admission order itself along with the memo saying that each of these petitioners pursuant to the entry of past case.
So each case have one memo to which IIT. Based on that, I can dispose of the. Do you have any objections? So I will say you are consenting and agreeing to the judgment passed by this lordship. So and so in this.
In fact, me and my lord is clearly conceding that the matter is covered, but the state government is contesting, not even allowing us to register.
But it just you are not made the state a party.
This is purely a case.
So you are appearing for all. So your name is shown for all. 1, 2, 3. What about 4?
So,
yaar adunu ಇವರೇ ಇರಬೇಕಲ್ಲ.
ಇರ್ತಾರೆ ಅಂತ ನಾವು ತಿಳ್ಕೊಂಡಿದ್ವಿ.
ಜೋಸಾ. So, respondent learned counsel Ajay Kumar Patil is present for the petitioners. Learned counsel Shiv Kumar representing Union of India for respondent 1 to 3 is present. He also accepts notice for respondent number 4. Registry to show his name, the cost list, as counsel appearing for R4 in all the 4 cases. Release these matters on 18th. Yes.
38, Majority PL.
Majority ಬೆಳಗ್ಗೆನೂ ಇಲ್ಲ ಇದರ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ರಿ ಮಿಸ್ಟರ್ ನಂಜಾರೆಡ್ಡಿ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
I'm sorry. Serial number 38. They sought for a mandamus to consider my representation submitted as per annexure E.
ಅವ್ರೇನು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ.
ಅದು 36 ಅದು that is urgent. Is 38.
ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನಂಜ ರೆಡ್ಡಿ ಅವರೇ?
Change of address, annexure of application submitted by me, page 20.
So we
Let
can
them
dispose of the writ petition.
That's yes, me.
What he says is, you have already given a representation.
Yes, my annexure of page 20, my lord, is there.
So why can't you consider that? ಇನ್ನೊಂದು representation ಕೊಡ್ಬೇಕಾ? Why? 29/10/22. So one more representation and you will consider it in what time? What is this? Change of address for as a society, no? Nursing college, no?
Nursing college.
All right, you gave one more representation.
Yes, yes. Let them consider this along with and I can submit one more, no problem.
Yes, searching for 1 and 2, Allah. The state of Madam Irbekal, AGA. So your request is from respondent number 1 only, right?
One only. Yes.
University.
Only university.
But Leonard Council says E. Nanja Reddy for petitioner. PS Sachin. Name is entry. Sai Prakash. Sai Prakash. Sai Prakash on behalf of PS Sachin for R1. ಬರಿಬೋದಾ ಇಲ್ಲ ಸಚಿನ್ ಹೆಸರು ಬರ್ಬೇಕಾ? ಯಾಕೆಂದ್ರೆ ಅದು the agreement with the university. We have that somebody else other than the council cannot appear. Already. Yes, Sachin ಹೆಸರಿನ for R1 and Leonard AGA for R. Petition is allowed. Writ of mandamus is issued to the respondent number 1 to consider the representation already filed by the petitioner at annexure F dated 29/10/2022. However, petitioner shall file one more representation in abundant precaution to the respondent number 1 university and within weeks time alagtire na?
Oh yes, indeed.
Yes, you want.
Within 10 days will last, sir.
Within 10 days from the date of receipt of copy of this order. And on receipt of the said representation by the petitioner to the first respondent university, the first respondent shall consider the representation of the petitioner and dispose of the same within 2 weeks thereafter. In accordance with law.
Yes.
Yes.
Obliged.
Facts ಬರಿಬೇಕಾಗುತ್ತೆ. Reasons to follow further. Yes, madam.
The petitioner is a petitioner. He has scored 190 and the percentage will come to 9.2 as per the marks. Can we tell them please and find out the marks? Please. Just take one day to the petitioner. First paper, he has scored total of 205. While doing the average loss, it has come to 51.25. And the respondent has considered 51 loss. When doing this exercise, petitioner has respondent has 1 mark. Similarly, it has taken the total is 181 and the average is 45. Considered mark is 45. In the entire considered marks, counting the average notes, respondent has deducted 2 marks. Thereby, the marks then if we have not deducted 2 marks lordship, then the average would have been 99 and he is benefiting the handling of the marks lordship. Lordship, this submission, similar submission has been considered by this honorable court lordship in writ petition, review petition filed in review petition number 384 of 21 lordship, annexure G page 33. It starts from there lordship, and the relevant portion is in para. It starts in the beginning lordship. Technically, going by the word of notification, the argument of one traditional university that the person has to be rounded off the nearest value can be interpreted rounding off of 50.25%. 50%. 50 is nearer than 51. However, golden rule of interpretation is that the interpretation of the provision should be made in such manner, especially in such cases, keeping in a view of objective of the legislation. The marks legitimately obtained by the student cannot be taken away. Out of 400 marks, the respondent student has obtained 400 marks. He reduced marks obtained by 400 to 100%. The arithmetical value is 125%. But this quote is one with the student and it is contended that 0.25% is also marks legitimately obtained by the student and at any rate same cannot be taken away. Therefore, although it is provided in the notification that arranging at the rounding off the stage, the marks shall be rounded off the nearest value. However, the point cannot be reduced less. Project here, what has happened is the respondent has reduced 0.25 to a lesser number. If you would have already have done that, yes. Project marks would have been here 52 lordship and 46 lordship and 52 and 49.
So 52, 46 and 52
And 49.
and 49. So how much will that be?
99 lordship.
So 199. So 199 means that would be.
9.7 and
So with 197, what's your percentage?
49.25.
25.
Because my entire this argument is that the petitioner's marks cannot be deducted. It is legitimately 10 marks.
$49.25 if it is 197. So you would have got +1 the first one, +1 in the second one, +1 in the third one, +3.
I'll be getting 199 because third one they have
+2 ಆಗುತ್ತೆ 97 +2 99 ಆಗುತ್ತೆ. 49.75 ಆಗಬೇಕು. Age?
Yes.
So your argument would be 0.25 is means it's lesser than 0.5, so it has to be the nearest lesser one.
This has been, this provision has been investigated by this honorable court in review. Interpretation. They challenge the decision of the court.
Oh, that review out of which petition?
Similar, I have, that is. Similar law. 174.
I think Justice Dixit's judgment is similar.
Judgment is.
Apparently 49.275.
ಇದು 17479 ಎರಡು ಮಾಡಬೇಕು.
Yeah, what he's trying to say is, when you get 49.25, the nearest rounding off would be to the lesser one, and it cannot be to the larger, the big next higher one, and his argument, correct? But whether the review petition has dealt with such situation,
Same, exactly same point.
then let's read that.
Page 36, 11 counsel for the petitioner university process for earlier decision of this question. To contain that the terms clause 5.1b contained in the ordinance governing postgraduate including diploma and in terms of the dated 20/9/2019. Just the record. Provision is made for rounding off the mark and averaging the rest of 4 points avoided by the evaluators from among the 5 evaluators. The same could be rounded off to the nearest value. There is no problem rounding off by converting from 120 marks to 100 marks. However, it is clarified that the decision in case of Anisha Esken was in respect of undergraduate and while in the present case the issue regarding the post-graduation students. Nevertheless, it is submitted that per contract learn from this there even from the minimum of review petition and baby respondent university and second by the 5 evaluators 101. But then by average the same point, it is shown as 50. Learned counsel for the respondent student submits. There cannot be any provision that could take away the marks legitimately acquired by the student. The learned counsel submits that it is evident by averaging the total marks for the showing 50.24. Similar is my case. And the para, I mean page 40 which I have read is the decision. But that is same case of NCA. In fact, the marks they are for one mark the student has struggled. But they can add, but there should be some legislation to take away those. It is something like we are going on
Your argument has been negative. Mathematically, you may be right, Mr. Girish. Mathematically and arithmetically, you may be right. But now what the court has held in these as beneficial legislation should go to the benefit of the students. Why did you make it in the next one?
Okay, not for the.
51.5.
In fact, after the batch of cases, of cases, by making a new ordinance for evaluation laws, have corrected the error, and for UG, they are telling the next time. But only for PG, this is made. This they have not corrected. All further that they have understood that they have gone wrong, and then they have increased, added the marks.
Next higher level.
Yes. There are two ordinances.
So you'll have to make it as next higher level instead of nearer level. Yeah. Yeah. But it may not be. Then why do you want me to discuss this? I will keep it with me. But again, that for entrance exam, it may be different. But here, they are already in the course.
The fact that this has been considered in a division with the number of figure diagrams now. Here, is for the entrance exam, and all the marks are counting for the ranking, and based on that ranking, limited number of seats for the admission will be allotted to candidates of the students.
There it will make a difference.
Yes. This is not the case. Here the student has already got the admission, and it is passing out of here the question is whether the student has completed the course or not. She is trying to get the admission for some. This, in my opinion, was because the facts are.
Minimum to pass. Then.
50%. ಇಲ್ಲ ನಿಮ್ಮ ರೆಗ್ಯುಲೇಷನ್ ಅಲ್ಲಿ ಇವಾಗ ನೀವೇ ಓದ್ರಲ್ಲ ಪೇಜ್ 18 ಅಲ್ಲಿ ಪ್ರೊಸೀಜರ್ ಫಾರ್ ಜನರಲ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್.
Procedure for general, all answers. Four evaluators, that each paper will be valued by another. And we not the years. Again, both papers has to be taken. There is a page for evaluation that is paper one this is the outcome of 1.25. We have rounded but whether the division paper 2 my lord. It is 1.5. We have given extra points. All promises no only. This is regulation says is that 8% as per the marks card, 8% of the all this paper one. Here the second charge.
This argument has been overruled and similar sort of argument, and this has held that until and unless the respondent goes before the complaint and set aside the order, or the law laid down by this Dr. Guru Prasad's case, they cannot take a different avenue. They have to take the decision by the rebel court in Dr. Guru Prasad. Lordship permits, I will produce all the decision. Learned friend has taken the objections, and all these points have been.
But how are you going to overcome Guru Prasad's case and the review petition which is filed? No, rounding off of golden rule and all that has been discussed in the review petition by His Lordship Devdas.
Yes. He entered in the master. Regulation says it is perfect. This model.
No, because it squarely comes within the Guru Prasad's case, and so also the judgment in the case of review petition. Dr. Nagadivya. And already the similarly situated persons have been granted. The court cannot take a different view, because this contention of yours is also considered. The review, the counsel for respondent to petitioner state pension. Unless you challenge this and get this set aside. If you want to find out, I will list it on Monday or Wednesday. Or I will allow the petition. Can be allowed. You want me to discuss this judgment? So I will say by virtue of Dr. Guru Prasad and that review petition, 0.25 is nearest golden rule. Only one petition, Allah. Third Learned Counsel Srimati Mana Baliga, petitioner, Learned Counsel Girish Kumar R for respondent university. Is the contention of petitioner. Is the contention of petitioner. After completion of his graduation in MBBS, petitioner was admitted to postgraduate degree in brackets PG in the discipline of MD Pathology in ESIC Medical College and PGI MSR Bangalore for the 2019-2020 batch. Petitioner took up the regular PG examination in May 2022. In November 2022, he took up the supplementary examination wherein petitioner was pretty confident completing the examination with good marks. When the results were announced in the official website of the respondent, petitioner found that he had failed the examination by 3 marks. This respondent awarded 197 marks to the petition out of 400 marks for the theory papers. In view of the petitioner having scored 197 out of 400 marks, averaging to 49.25, he was declared as failed. Immediately thereafter, petitioner applied for digital evaluation of slip. And after evaluation, he realized that it was an erratic evaluation and marks awarded was not consistent. Petitioner had scored 51, 48, 52 and 49 respectively for the 4 papers, theory papers, 4 theory papers out of 100 marks each. Thereafter, the petitioner immediately rushed to the respondent and requesting the respondent to round off the marks of the petitioner to the nearest higher level to benefit the petitioner, which was given in the previous batch of students in the petition number WP 11348 of 2020 and in other similar petitions. Wherein the similarly situated students who had obtained 49.25% of marks were rounded off to 50% as per the ordinance, and they were declared as pass. But however, the respondent refused to entertain such a plea of the petitioner, rejected the same. It is further contended that the evaluation of PG course is governed by the ordinance governing post-graduation, including diploma and super specialty evaluation dated 29/3/2019. According to clause 5B of the said ordinance, for passing the examination, the student is required to secure 50% in the theory examination in aggregate and 50% in practical plus viva examination. In similarly situated circumstances, students who had scored at an average of 49.75% had approached this court by challenging the action of the respondent in WP number 11348 of 2020, wherein a direction was issued by this court with the following effect. Extract para 8 the direction in the italics. Learned Counsel further contends that based on the order passed in the above stated writ petition 11348 of 2020 within brackets EDN education, the respondent placed the matter before the syndicate meeting, which discussed the aspect of rounding of the marks, and it was decided by the syndicate meeting that in marks that is awarded should benefit to the students, and it was decided to and opined by the members of the syndicate to exercise this option prospectively. And accordingly, the respondent gave the benefit of this decision to the similarly placed students who are approached the court, this court. Learned Council further contends that due to the COVID-19 pandemic situation across the globe, which was largely affected India, the academic study of the petitioner was disturbed. College could not conduct regular classes. First wave of COVID from April 2020. Proper classes were not conducted between March 2020 to December 2020. And from April 20 to June 20, PG students who are put on regular duty, a continuous period of 7 days, and then a break of 7 days and so on. And apart from this, they were on 6 to 8 hour duty on a regular basis. In view of the COVID emergencies, they were limited to the scope for exposure to other type of cases. Learned Council further contends that pursuant to the placing of the order of this court in the syndicate meeting held on 12/11/2020, the rounding of marks after taking the average of 4+1 valuations and after taking total average of the marks for prospective effect as to benefit the students was implemented. The petitioner was constrained to approach this court because of non-application of mind of the respondent in not applying the methodology of rounding off to the next higher level. Thereby has not properly computed the aggregate of marks and declaring the petitioner as failed, has perforced the petitioner to approach this court. Per contra, Learned Council representing the respondent university vehemently contends that there is nothing wrong in the decision passed by the university in awarding of marks, as the marks obtained by the petitioner admittedly at para 4 of the writ petition produced. Para 5 of the writ petition clearly evidences that the petitioner has secured marks of 51.25, rounded off to 51, 45.25 rounded off to 45, 51.5 rounded off to 52, and 49 in 4 respective subjects. Therefore, the respondent has rounded off the number to the nearest value, and therefore it cannot be considered as illegality or arbitrariness on behalf of the respondent. stop. I will heard learned counsel for the petitioner in this matter. It is to be seen in this present facts and circumstances of the case that the petitioner, having secured 51.25 marks in the paper 1, requires to be rounded off to 52, and 45.25 scored in paper number 2 requires to be rounded off to 46 for consideration of the average marks of the petition. Learned counsel for the petitioners relied on the judgment of Dr. Guru Prasad in WP number 11348 of 2020, within brackets ED and RES, wherein this honorable court, this court has rounded off the marks taking into consideration paragraph 5(1)(b) of the ordinance, which clearly reads, extract the 5(1)(b) of the ordinance, which is mentioned in page 22 within brackets BL, average of the best total marks. Learned counsel also relies on the judgment of coordinate bench of this court in the case of Rajiv Gandhi University of Health Science versus Dr. B. Naga Divya in review petition number 384 of 2021, wherein similar situation arose before this court and similar set of objections were raised by the learned counsel representing the respondent, and having adverted to the rival contentions of the learned counsel for the parties, the coordinate bench of this court has held at para number 6 of the review petition. Technically speaking, page 40 mark it, riddle mark again. Technically speaking, till page 41. So this has to be given to other students also as ordered. But ನೀವು ಮಾಡ್ತಾ ಇಲ್ಲ. Why don't you implement this? It come to the benefit of the students. See, according to me, education is arts is just a merely a classification to show how you stand a step. But that should not be a curtailing method to put down somebody to progress in life. I don't know how many classes of law you would have attended and how many she would have attended, or how many of the judges, how many they would have attended. Nevertheless, when people are being given certain benefit, and that benefit has to go in favor of the students when it is beneficial legislation. All beneficial legislations should favor the student. So I will restrict here only to the petitioners. Till page 42 marked in red. Under the circumstances, these two judgments derived by learned counsel for the petitioners squarely applicable to the present case on hand. The marks obtained by the petitioners in paper 1 and paper 2, to the extent of 51.25 in paper 1, requires to be rounded off to 52, and 45.25 in paper 2 requires to be rounded off to 46. Thereby, the total average marks that would be secured by the petitioner would be 199. Thereby, the petitioner would be getting an average of 49.75. No, 199 mandre, 49.75 bro. 49.75, which requires to be rounded off to 50. Yeah? The nearest higher value, the nearest value 50. And as held by in the review petition, the golden rule requires to be adopted in a beneficial legislation of this kind. And always it has to go in favor of the student. Hence, the petition requires to be favored and accordingly it is favored. Petition is, accordingly petition is allowed. Writ of mandamus has to be issued now. Writ of mandamus is issued. The direction to the respondent university to award the, to round off the marks to the next higher level, that is from 49.75% to 50%. In the discipline of MD Pathology RS3, number 22. And the further next direction, the respondent shall issue fresh marks card after rounding off the marks from 49.75 to 50%. Same shall be done within period of 4 weeks from the date of receipt of copy of this order. Yes, madam. Thank you. Thank you, Mr. Girish. Standing counsel agibitidare ee court ge. Division bench alli ನೀವು ಇರ್ತೀರಾ? ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ RG ಎಷ್ಟು? Mohammed Tahir idara? Tomorrow, all right. Tomorrow, baralla, day after. Any urgency?
Melats, Mr. Khetty requested me, Melats, to seek for Monday, Melats, in case.
Have it on Monday.
He requested to
come on Monday at request of counsel for petitioner and respondent number 3. Yes, madam. Monday.
Grateful.
These are